Good morning. Can I welcome members to the 25th meeting of the Education and Culture Committee in 2013. Can I remind all those present that all electronic devices should be switched off at all times. Our first item today is to agree whether to take item 4 and item 5 in private. Do members agree? Okay, thank you very much. Our next item is to continue our evidence taking on the Children and Young People Scotland Bill. And before I welcome the panel to the committee, can I welcome Marco Biagio, who's here as substitute for Joan McAlpine. Welcome back, Marco. And can I welcome the panel this morning. We have Tam Bailey, Scotland's Commissioner for Children and Young People, Juliet Harris, Director of Together, Alan Miller, Chair of the Scottish Human Rights Commission, and Sam White, Domestic Policy and Parliamentary Manager for UNICEF UK. We intend this morning to explore a number of themes, including the duties related to the UN Convention on the Rights of the Child, the extension of the Children's Commissioner's powers, and the named person and information sharing areas. These are our main areas of interest this morning. There might be other things that pop up, but those are the main ones. I'm going to start the questioning straight away because we've got a lot to get through this morning, including some budget scrutiny, and I'm going to begin with Jane Baxter.
Thanks, Convener. Morning. I'm going to begin by asking about the implementation of the UN Convention on the Rights of the Child. And I'd like to start by wondering whether the witnesses think that that implementation requires it to be incorporated into Scottish law.
I'll kick off. Yeah. First of all, I welcome the intentions of the Scottish Government of further embedding UNCRC within the legislation, although it's quite clear, you've seen from my written evidence, that I think that the end point in that should be incorporation. In fact, I've called upon the Government to give us a roadmap towards incorporation. The reason for that is quite simply, I think it will lead to better outcomes for children and young people. And I've given some examples in the supplementary evidence on leaving care, and leaving care being one of the issues which is actually taxed this very committee, about the early age at which young people leave care. And I think if we had UNCRC, that would be an example where it would be much easier for young people to seek redress in those situations when they leave care. And I know that the committee's had legal opinion, or one legal opinion with respect, in terms of questioning the feasibility or the appropriateness of having the UNCRC incorporated. And I have to say that that's one legal opinion among many, because there are other legal and academic opinions who are of the view that it's possible to incorporate UNCRC into Scots law. But it's a complex issue, and it's complex because of a number of areas. Firstly, in terms of transposing from international obligations into domestic law, there's 54 articles in UNCRC, and it would have to be careful consideration about how you manage to get our international obligations actually embedded appropriately and effectively into our Scots law. The second one is that the articles cover a whole range of responsibilities, some of which are devolved quite clearly in terms of education, in terms of health, some of which are a mixture of devolved and reserved. For instance, Standard 11, which has got powers at Westminster, powers at Scottish Parliament, some of which are quite clearly reserved in terms of, for instance, asylum seekers. And another complication is you would need to actually look at what kind of means of redress was actually built in as a result of any breaches in terms of UNCRC. So I've looked at the evidence, and I think it must be quite difficult to make sense of these conflicting views about incorporation or not. And I think that one of the things which this committee could usefully initiate through its committee report is to suggest an inquiry, a parliamentary inquiry, into the feasibility of the incorporation of UNCRC, which I think would provide the basis for teasing out some of these differences of opinions and actually allow proper consideration of incorporation rather than as just part of what is quite a complicated and wide-ranging bill. That's the first point I want to make. The second one is about the ministerial powers, and I've already given evidence that I think this is actually rather weak, and I think you've had evidence from others who concur with that particular perspective. And basically it's because there's so many areas of discretion that it's difficult to see how that ministerial duty would be enforceable if it wasn't being upheld. And I think we should go back to UNCRC, look at the articles that could reasonably be included in the face of the bill. For instance, we've already got best interest in our legislation, best interest which is narrowly defined through the 95 Children's Act. And I think that that could reasonably be considered as something that could become part of the ministerial duty. We've already got practices in Scotland where increasingly the views of children and young people are sought and are seen to be relevant to the development of policy and practice, and I think the views of children and young people could reasonably be part of the ministerial duties or the duties that are included in this bill. And in fact, I'm giving you advance notice of maybe some of the suggested amendments that I would be prepared to actually do some work on and come to as part of the amendments in stage 2. And the final thing I'll say, very quickly, is that the stated intention of the bill is so that Scotland becomes the best country in the world in which children grow up. Scottish Parliament's actually got a rather proud record in terms of rights. You've got my own institution, Scotland's Commission for Children and Young People. You've got the Scottish Human Rights Commission. And I was at a meeting last week in the European Parliament as part of a network of the European network of ombudspersons and children's commissioners. And I was on this side of the table as well, with MEPs who were thumping the table to say, you need to make sure that the UNCRC is as firmly embedded in your legislation as possible, because in their view, that's what made the difference in terms of outcomes for children and young people across Europe. So I hope that we can actually have much greater discourse about UNCRC and the potential for that to actually become more firmly embedded than some of the measures that are currently within the bill.
Okay, thank you. Do other members wish to comment? Alan.
Thanks very much, Convener, and thanks for members of the committee for inviting the Commission. Picking up on the question and the answer from Tam Bailey, with which I agree, I think that this committee and the Parliament and the Scottish Government really need to engage much more with the international human rights system, including the UNCRC, and the experience of other countries as to what they have done in these areas. And I have to say that this part of the bill, the reluctance, the hesitancy to really engage with international human rights system is not of these times. It's a very inhibited, sort of inward-looking kind of approach towards the best way of promoting and protecting the human rights of children. And I say it's not of these times because we're at a time in Scotland where everyone is looking to see what kind of future country do we want, what kind of Scotland, what's the place for children in it, what's the place for human rights in it, and whether it's going to be after the referendum more devolution. Then we only need to look down the road to Wales, where they have, under devolution, taken a more positive approach through a duty of due regard to the UNCRC. If it's a yes vote in the referendum and it's independence, Scotland's going to be a member of the United Nations. And we have to be quite fast in understanding what the United Nations and the human rights system and the UN Convention on the Rights of the Child, what that actually entails, what these obligations are. Because even under the Scotland Act at present, there is an obligation to observe and implement the UK's international human rights obligations. So we really have to be thinking bigger. And I find the bill and its reluctance and retreat from even a previous consultation on incorporation of the UNCRC, it's just not of these times. And I think this is an opportunity for what Tam is saying, for really us to get our hands much more around international human rights system, not to follow the path that the UK has taken, which is to refuse repeated recommendations from the UN to incorporate the UN Convention on the Rights of the Child, as well as other international human rights obligations. We should be much more outward and forward-looking, particularly in these times.
Juliet.
I'd really like to echo what both Tam and Alan have said. And I certainly agree that now's a time for the Scottish Government to really be ambitious about what we want to achieve for our children and young people. It's really a time, as you know, we keep on bringing incorporation to the committee and to everybody's attention. And I think it's really time, if we are going to make rights real, if we really do want Scotland to be the best place to grow up, we need to be brave. We need to really show that commitment in legislation. And we keep on talking about incorporation because we see incorporation as being the way that we can really have a strong legal framework that enables the protection and the provision of rights for children and the participation of children within civil society and within the decisions that affect them. We really want to see systematic and accountable and transparent consideration of children's rights, and that's absolutely essential if we're going to succeed in making children's rights real. We want us to all have a common knowledge and an understanding of what children's rights actually are, what they mean. And it's really important that adults have this understanding of children's rights as well as children and young people themselves. And we also need to know, are we making rights real? What impact is this legislation having? We need to know that there's clear, consistent monitoring frameworks in place so we can actually see what impact legislation's having on children's outcomes. For us, incorporation is the way that we're going to achieve that. But certainly there are very many steps that we could take on the roadmap towards incorporation. And I'd really urge the committee to consider some of these steps that can be taken and certainly look at the big picture, be ambitious. And if we are going to make rights real for children and young people, really look at what we're trying to achieve through incorporation and try and include that in this bill.
Thank you. Sam.
Just a couple of really small additional points. Firstly, UNICEF UK did a big piece of research last year where we looked at international examples of incorporation. One of the reasons for doing this was really to be clear about what impact it had on children at the end of the day. This is why we're all here, that's what that's about. And the thing we found was that where countries had incorporated or did have legal measures of children's rights in place, that was where it made the real difference in terms of a cultural change and a legal shift for children. We were seeing policy and legislation being developed in a different way. We were seeing it having a much stronger impact in terms of children's services at a local level. There are examples of incorporation in a number of countries. There are examples of the incorporation of the general principles of the UNCRC in other countries also. But very clearly the message from the research was the actual decision to give legal force to children's rights, however that may look, is the decisive factor in what difference it makes for children. Obviously, as an organisation, UNICEF UK supports direct incorporation of the Convention. We're very much of the view that both civil and political rights, but also economic, social and cultural rights are justiciable. I know there have been some questions about that. But certainly the Committee on the Rights of the Child is very clear that economic, social and cultural rights are as able to be interpreted by the courts in an appropriate manner as civil and political rights. So it's certainly something we'd like to see going forward. And just very briefly in relation to the duties in the bill, the fact that the Scottish Government is putting forward a statutory expression of children's rights is very, very important. It's something that isn't usual across the world. We do see state parties failing to do that, and that in itself as a principle is very important, but the duties that underpin that expression need to be strong, and we feel there's a long way to go at the moment in the bill.
Thank you very much. James?
Yeah. I wonder if you'd like to say a little bit about which individual rights you think are not already reflected in some way in domestic legislation.
I gave two examples there of best interest. And we do have best interests actually as paramount through the 95 Scotland Act. But we're trying to look much bigger than this. And in fact, the ministerial duty to its credit is across all ministerial functions.
Clarify. Jane's question was very specific, I think. Which, if I'm right, effectively, what parts of the incorporation are not already reflected in some way in domestic legislation? And you said, for example, a given one is in the 95 Act. Well, surely that means it's already in some way reflected in domestic legislation.
Yeah, but that doesn't apply to all matters concerning children. It concerns the matters that are covered in the 95 Act.
So,
and the intention
in some way it is reflected in domestic legislation?
In a very narrow way, and that's the words that I used. It's in a very narrow way through whichever matters are considered through the 95 Act. It's not considered, for instance, in planning applications. You know, you don't have to take the best interests of children into account in matters like that. And I think that the expansion of best interests across all our considerations of children would be a very worthwhile thing. You don't have to consider the best interests of children in setting the budget. You're going to have a discussion about the budget. So there's a whole host of areas where, if we really truly want to put children and young people at the centre of our policy making, at the centre of our concerns, that we have to have a much wider perspective than just the way that we have incrementally built up our legislation. That's just one of the articles, and it's one that I feel quite strongly about. And in terms of the views of children and young people, it's very rarely actually embedded across the legislation in a consistent way. And yet our practice, it's commonly accepted that our practices are about listening to the views of children and young people. We're in a different place than where we were 10 or 15 years ago, but it's not properly reflected in all of our statutes. And yet there would be an opportunity through this bill, if you actually included that as part of the ministerial duty, it would be a much stronger basis than anything that it's like just now. And those are just two examples.
Does anybody have any differing view from that? No, okay, because I want to keep this moving along with a lot of areas. Jane, do you any
No,
further
I'm happy,
supplementaries?
that's fine,
Okay,
Convener, thank
Claire.
Yeah, it was just a question from Mr Miller, who opened up the hypothetical situations of the future. But obviously, at the moment, we are a devolved government, and there are certain aspects of legislation that are not within the control of the Scottish Government. But you raised the concerns about if the UK Government continues of the path, and I think there's been reports this week that they might actually drop the Human Rights Convention. If the UK Government moves away, how will that impact on what we've put in legislation in Scotland in terms of UNCRC?
Well, I mean, under the Scotland Act as it stands just now, there is an obligation on the Scottish Parliament, the Scottish Government, to observe and implement the UK's international human rights legal obligations. The UK, at least part of the coalition government, has said that it will go into the next election with a manifesto commitment to repeal the Human Rights Act and possibly withdraw from the European Convention on Human Rights.
The Conservative Party have made a commitment.
Yes, that's what I said, part of the UK government.
Yeah, but the Conservative Party
Yes.
have made a commitment. Right?
Yeah.
I think that's what Mr Miller said, actually.
Well, he said part of the coalition government, which... let's be explicit about this.
Touchy there.
Well,
Touchy.
no more touchy than you.
Yeah. If that's an indication that the Liberal Democrats are clearly not going to take that position, I would certainly welcome that.
I think
and
Nick
expect
Clegg made that explicit
Yes.
at conference.
Yes. So I would certainly welcome that. That wouldn't take away the responsibility for Scotland if it continued to be devolved and part of the UK to do what the Scotland Act currently says, which is to observe and implement existing UK international legal obligations, part of which is to implement the UN Convention on the Rights of the Child. So that in all those areas that were devolved, it would be open for Scotland and its responsibility to take a different direction than a future UK government, possibly, by doing more to implement the rights of children.
Can I just clarify a couple of points? I mean, some witnesses have called for full incorporation. But under the current settlement, effectively, how could we possibly fully incorporate UNCRC, given the fact that you already mentioned that some are devolved, some are reserved and devolved, and some are reserved? In what way could we, how could we fully incorporate? It doesn't seem possible to me. Well, whoever wants to answer.
I mean, you can incorporate in as far as the devolved powers allow. But the reason I suggest that we have a parliamentary inquiry is so that we actually tease out that which can be done under the current settlement, and the timing of that inquiry may well open up other possibilities. But I do think that parliamentarians, and particularly this committee, have got an opportunity to actually seriously consider the steps that we would take towards incorporation. And you're right, that's the very reason that I highlighted the different levels of devolved and reserved powers. And that's not the only matter which makes it complex in terms of incorporation of UNCRC. But I would warmly welcome if the committee recommended that, because I think actually it would help us map out what can and can't be done within whatever constitutional settlement that we reside in.
Sam.
Just an additional point that the Human Rights Act obviously is a piece of domestic law. If that were repealed, and we would very strongly hope it wouldn't, because it applies as equally to children as it does to adults, the international obligation would still apply unless the UK government withdrew from the ECHR, and it would certainly still apply in relation to the UN Convention on the Rights of the Child. And probably worth noting is that incorporating the CRC, obviously it would need to be done with regard to devolved matters, but the vast majority of things that would affect children in their day-to-day lives are devolved matters. And I think that's quite important to remember. There's also been a recognition by UK government in relation to children potentially raising concerns with Scottish Children's Commissioner, and that they should be able to raise those whether it relates to a reserved or a devolved matter, because children really don't care about that distinction. You know, it's about what's going on in their lives now. So I think there's an element of flexibility there as well.
Just one final question before I bring in Neil, and I know he's got another question. Are you really saying, for example, let's take one particular right, and that's the right to play. Are we really saying that if we incorporate UNCRC into domestic legislation, that the right to play would then, if that was challenged in some way, or somebody said that their rights had somehow been broken, or in some way they were being forbidden or stopped from playing, that in some way that would then be a matter for the courts to decide? Is that really what we're saying?
I wouldn't start with the challenge. I would start with the impact that that has on our approach to play.
Yeah, but my question is directly, Tam, to be honest, and let's be clear here, is about, are you saying that if the right to play is in domestic legislation in the way that seems to be suggested, that then would be, if it's challenged by somebody, then that would be a matter for the courts to decide?
As an end point, but I go back, the purpose of having a right...
So that's a yes,
it's a yes, but the real impact will be on the approach that we take to children's exercise of that right to play. So right now, we pay lip service, quite honestly, to children's accessibility to play. Particularly, I would say, children with disabilities. They come at the tail end of every consideration. So yes, the end point may well be that there's a right of redress through courts, but the real impact of that is the way that we approach play, is the way that we serve our children and pay proper attention to the developmental, cognitive and social development that can be had through play. And we don't pay nearly enough attention to that. And in fact, there's been a general comment which provides guidance to state parties who are signatories to the UNCRC and how they can make that, how they can give better effect to that. So the real impact isn't about whether it's challengeable through courts, it's how we actually deal with our children. It's how we make sure that their development needs are met through, in this instance,
I'm sure you would accept, Tam, that we have to look at both ends of that particular
problem.
And while I accept what you're saying in terms of the cognitive development and the rights of children, particularly disabled children, I accept all of that. I'm just asking a hypothetical question, which is, are we really saying that potential breach to the right to play would be something that we would want our courts to be involved in?
At the end of the day, you will build in rights of redress, but they won't determine what action that we take to make sure that children actually enjoy that right to play. That will still rest with the policies and the implementation at local level. And effectively, that will be the impact of it, to improve the attention and to improve the way that we deal with children's enjoyment of that right to play. That's the whole intention of it, not to look at just the end point.
Thank you. Very briefly, so I want to move on and just want to try and clarify that point.
Just to make a point that in countries where children have had enforceable rights, there's no evidence of a massive increase in strategic litigation or children going to the courts. It's rarely in children's best interest to end up in a court environment, so that would be looked into in terms of any rollout of incorporation.
Thank you. Neil.
Thanks, Convener. Concerns have been expressed in written evidence and already this morning about the weakness of the duty on ministers. As proposed at the moment, ministers will keep under consideration the UNCRC. Obviously, would hope they would do that at the moment. Stronger duties have been suggested a due regard duty or an act compatibly with duty. What is your preferred duty, and what would be the practical effects of changing the duty from keep under consideration to the one you're proposing?
I'll start with Juliet.
Yeah, I've already commented on that.
I think we need to look at the qualities of the duty that we really want to see, and we really want to see a duty that really gives a systematic and accountable and transparent consideration of children's rights. And so we want to be able to see when ministers are considering children's rights, how are they doing that? Are they doing it that in every single instance? How are they going to be accountable for children in their consideration? And not only do we want to see the systematic consideration of children's rights in ministerial decision making, but we actually really want to see what the impact of that systematic consideration is in the decisions that they have around children. And so how does that decision making actually translate in terms of policy, legislation and service provision? And so I can't go into the detail of exactly what duty we want, but certainly I think it's really important that whatever duty we do get through this bill, that it systematically considers children's rights across all areas of policy making. So it's across environment, transport, not just those things that directly relate to children. And that ministers are held to account so we know what's been involved in that decision making, and we see a result of what they found out through that decision in the actual practical application of what they're going to of the legislation that they're going to bring forward. Certainly from our opinion, then acting compatibly with the UNCRC would be a very strong duty that would have all those qualities.
Okay, thank you. Alan, did you want to add something?
Yes, a very good question, and I think it does point to what we've been saying earlier about the need to have more open, honest, mature debate about the different ways in which incorporation can take place. We are fortunate, though, in Scotland that we have, quite a lot of experience now of devolution and the Scotland Act and the Human Rights Act, and how the two combine with one another as part of the existing constitutional arrangements in Scotland. So there is a lot of learning, because by and large, I think it would be agreed that that combination of the Human Rights Act and the Scotland Act has worked pretty well. Parliament is sort of used to the requirements to comply with the European Convention and its legislation. Public authorities understand what their duty is to act in a manner that's compatible with the Convention, as do the courts. So acting compatibly with similar sort of arrangements as the Human Rights Act gives to the European Convention human rights would be one way. But really we need to have an open, mature debate, learning from the experience of other countries. But just looking at our own experience under devolution, that's one path to be explored.
Just to add to that, I mean, UNICEF UK certainly would like to see a stronger duty on ministers across government. As Juliet mentioned, it would need to be meaningful and a real departure from the status quo. Fundamentally, what we want to see is a duty that covers both process and outcome, so act compatibly works reasonably well. There are obviously other examples. The original duty Scottish Government proposed was due regard. That reflects what's currently in legislation in Wales and has had quite a transformative impact on Welsh Government and the way it approaches children's legislation and policy. There are lots of types of duties, but really the principle is about how do you get systematic consideration of children's rights, not only in areas that deal with children's services, but also in areas that don't do it as a day-to-day. The key thing really for us is what are the underpinning mechanisms that make that duty work in practice, and it feels to us at the moment that those things are missing from the bill. So we're looking at things to achieve that systematic consideration, so whether that's child rights impact assessment, whether that's a really detailed reporting duty. At the moment, the bill asks ministers to report on what they've done to implement the convention, so it doesn't really monitor how they're delivering the duty, which is a weakness in terms of holding government to account. And one thing that they have in Wales that has really helped roll out the duty and really make a difference across government is a children's scheme, which sets out the how in terms of how this duty works in practice. And I think we would welcome, certainly from the Minister, more clarity around how this consideration duty will work in practice. It's a rather unusual wording.
Yeah.
Thanks. You mentioned Wales there, and you mentioned the original proposal here in Scotland to have a due regard duty, and Wales having a due regard duty. Why are Wales having a due regard duty and we are not? Do you know why that's the case? And also in terms of, you mentioned the children's scheme in Wales, understand they also have children's rights impact assessments in Wales, and this is, I think UNICEF have called for this to be on the face of the bill. What difference would children's rights impact assessments have?
Very quickly, I'm going to start again. Put this in again, Tam.
Yeah, okay. Your first question was why there's not due regard. I really think that has to be a question for the Minister, because the government produced a bill, a rights of children and young people bill, which was the main proposal, and it's now not there. So I really think that's a matter for the Minister. The second thing about child rights impact assessments, we have consistently called for a child rights impact assessment because I think that would provide a better understanding from the government in terms of the actual impact of their proposals. And I would still say at this stage that I would encourage the government to actually look at that. And again, that may be something that you would want to ask. Can I just add something about the ministerial duty? Because I know I already commented on it. This isn't just about ministerial duties. This is about what happens actually at the local level, because it's public bodies that make things different and that actually have got the responsibility to do the best by our children and young people. So it may well be that at stage 2, it's worth looking at how we can strengthen those duties on public bodies, because they're the people that day in and day out either realise children's rights or not.
Yes, Julie.
I'd just like to take the second part of your question around child rights impact assessments, because, you know, we've written to the committee on behalf of Together and its members about the need to undertake a child rights impact assessment on this bill. And we feel very strongly about the need for child rights impact assessments to be introduced as routine, not just on this bill, but on all future legislation, because it really does help to ensure that any unintended consequences of legislation are really considered, that they're predicted, that they're monitored, and if necessary, that they're avoided or mitigated. And I think there's a very good example at the moment. A lot of the time of the committee here has been spent talking about named person and information sharing. And I think there's still debate going on now about where the balance is between the child's best interests, the right to privacy, about the need to share information in terms of early intervention. And really this should have been picked out earlier on in the process, and this would have been picked out earlier on in the process if there had have been a child rights impact assessment undertaken on this bill in the early stages of its development. So I think that's a really key example to bring to the committee's attention, and it really highlights the importance of ensuring that child rights impact assessments are introduced on the face of the bill and are routine from now on forward. It just makes sure that children's rights are considered in every piece of policy making, and it means that these debates are really taking place earlier on when legislation's first put together rather than at this later stage.
Okay, thank you. Do you have any brief comments, Sam?
Yeah, very briefly. One of the interesting things about child rights impact assessment is they're used as a tool worldwide. So they're not a new concept, and they're very much seen as a way to help develop policy that really works for children. They're used, obviously in Wales, we've talked about there's been some significant changes there, not least of which has been the increased involvement of children in shaping and developing policy and actually being engaged in budget discussions as well. We've seen them really well used in Sweden, Norway and Belgium, where they've really impacted on how government works. But there's also examples of local child rights impact assessment, not only in places like Australia and Canada, but also here in Scotland. We're working with Glasgow City Council to help them develop a child rights-based approach to the delivery of services, and certainly those kind of ideas are being brought in through that. And I know they've been used in Fife and in Edinburgh and other places as well. So it's a fairly familiar process, I think, for most people who develop, whether it be policy or services.
Can I just check something? The government's, well, you'll have seen the correspondence from the government about this issue, and their view, in summation, is that much of the work that would have been done through a children's right impact assessment has been done through the work that they've carried out, the consultations and all of the other stuff they've done. So why is it necessary to carry out a children's rights impact assessment if all of the work is done but it's just not called that?
Firstly, I don't agree with that assessment. I think that it would be much more comprehensive to methodically work through the document in terms of the proposals and the impact on children's rights. But secondly, if that's the case, then it should be no problem for the government to actually produce a child rights impact assessment on the basis of the work that they've already done. They failed to do so, and they've been repeatedly asked, and it's a little bit mystifying as to why they're so reluctant to carry out a child rights impact assessment on the very piece of legislation that is meant to, or it's designed to progress children's rights. To me, it doesn't make sense that they haven't produced a child rights impact assessment, and we've offered plenty of assistance on that.
Juliet and Al.
In the letter that we received from the Minister explaining the reasons why a child rights impact assessment hadn't taken place on this bill, then she specifically stated the impact assessments that have taken place: privacy impact assessment, the equalities impact assessment, business regulatory impact assessment. And the one thing that all of those is really missing is the specific needs of children and the impact of legislation on the different ages of children as well. When the Minister talks about the equalities impact assessment and the fact that the bill's been assessed in terms of its impact on LGBT children and children with a disability, it doesn't take into account actually how the bill will affect children of different ages. And obviously the need of a very young child is very different to the rights of a teenage child. And it's really that recognition of the different ages and stages of child development, and that really needs to be taken into account in terms of this bill, and that would have been unpicked in a child rights impact assessment.
Very briefly, because I know you do want to move on to these other areas you identified at the beginning, but I think just one thing to add to the comments I agree with is an impact assessment. I think one of the lessons looking at how Parliament has operated since devolution is that no matter who's in government, there needs to be more transparency and explanations given to the public about not just the views that were received through a consultation, but what the government then made of them, what analysis it had, what reasons it therefore has for agreeing with this point and not that point. With this bill, for example, one of the reasons given by the government earlier of not doing more to incorporate the UN Convention on the Rights of the Child was that it might be in conflict with the rights of parents as it was perceived under the European Convention on Human Rights. Now, a lot of consultation submissions, including from the Commission, said this is a false conflict that you're creating. These two instruments can be harmonised. So if that's the reason for being hesitant on incorporation, it should be taken off the table. And if you don't agree with that, then let's have more of your reasons and your arguments for it. We haven't had that kind of engagement, transparency or open debate. And that's what makes it, therefore, difficult to accept that an adequate amount of impact assessment has been done when even something as straightforward as that hasn't really been brought out into discourse and satisfaction given.
Thank you. Liz Smith.
Mr Bailey, can I take you back to some very interesting remarks you made in your opening statement about the one of the difficulties of the bill is the fact that there is potentially conflicting legal advice. Because you said that you felt it was perhaps inadvisable that the committee had only taken one piece of legal advice on that, and that you implied that other people who do want the incorporation of UNCRC had taken different advice. Could you tell us where you think there is a point of conflict between the advice that you have had and the advice that has been given to us as to why it is not appropriate to incorporate it? Where are the issues? I'm not asking you to define where you think it is, but where the issues are of a disputed legal opinion.
Well, there's been very broad criticism offered that it's bad law, it's bad policy, it's bad practice. That's just simply not the case. In the view of other academics and other legal experts. And I think that the committee should actually, as I said previously, facilitate the opportunity for these conflicting views to actually come across. Because the advice that I've got is that within the devolved powers of Parliament, that it would be possible to look at the incorporation of the UNCRC. notwithstanding the fact that the point that was raised earlier about the differences of devolved and reserved powers.
Could I just push you a little bit further on that? When you say about something that's bad law or good law, I mean, there obviously we get
well,
lots
it wasn't
of
my phrase. I was paraphrasing.
We get different interpretations of what that means. But are there specific areas of what is suggested in the bill where you think that the legal opinion that we have so far been given is not accurate?
Well, it was that blanket statement about it being bad law, bad practice, bad policy. I mean, the hesitancy of the government, and I hope not the committee, in going for something that's actually much more substantial in terms of the UNCRC, I would like to actually dispel that and to actually give the committee confidence that you could go further. But I understand some of the reluctance because of the advice and the discourse that's taking place till now.
Could I just finish on the point? Do you believe that the people who are advising yourself and others who do want that incorporation dispute some of the content of the government's spelling out of why they don't think that it should be incorporated? Is there an actual dispute over that?
Yes, I'm not actually clear what the government's hesitancy is, because I don't think that's been made explicit. And I would be most interested to hear the explanation of the government, for instance, in why they didn't go for jury guard, or why the ministerial duties are framed in the way that they are and are not firmer in terms of what would be expected of our ministers. So I think the government have stepped back from jury guard, which I gave a welcome, I gave a cautious welcome to, because it's not perfect, but I gave a cautious welcome to that particular proposal. And now the proposal where we're sitting just now is a much weaker ministerial duty. So the point of dispute is we could actually go beyond where the ministerial duty sits right now. And that's the legal advice that we have, that you could actually go beyond that and look at incorporation within the confines of the devolved administration as it stands just now, or devolved powers as it sits just now.
Okay, thank you.
We're bringing Liam MacArthur at this stage. Liam.
Just very briefly, I was interested in what you were saying, Alan, about the interaction between human rights legislation and the Scotland Act, because I think Professor Norrie, who's been probably the most outspoken critic amongst the witnesses we've had so far about incorporation, was suggesting that the common law structure of our law makes it inadvisable to go down the route of full incorporation. But just to be clear, in terms of the experience in terms of human rights legislation and that interaction with our common law structure, that should allay fears, in your opinion, that this does not kind of pose perils and all the rest of it, as has been suggested?
Yeah, absolutely. I mean, the experience, I know everyone has their views about this case or that judicial decision, but the Human Rights Act and the Scotland Act, by and large, have worked well as one of the pillars of the constitutional arrangements of a devolved Scotland. And we're all quite familiar now with what it means for each of us. Also, the Scotland Act, in a sort of, maybe one of the secrets of the Scotland Act, you know, there is a provision in there on the Scottish Government to observe and implement UK's international obligations. So, whilst we can have different legal opinions about incorporation and the different interpretations and implications of that, at the end of the day, from the point of view of the rights of children and outcomes, it's implementation of the UNCRC that really matters. And that already is in the Scotland Act in terms of a duty that really needs to be much more put into practice.
So, I go back on this because I think this is a crucial point. You know, this difference between incorporation, on the one, which many people have just said, this is what you have to do, you have to incorporate, and what you suggested there, which is effectively making sure that these duties, these principles, these rights are taken forward in Scotland through our domestic law, but not necessarily through incorporation. I mean, I'm trying to. I was going to ask a question about trying to ascertain what the practical impact, not the cultural impact, because many of you have mentioned the culture changes, but the practical day-to-day impact has of incorporation versus doing all of the same sort of stuff through domestic legislation, but not actually incorporation. What's the difference? Sam?
I think to try and answer all those points in one, I think in terms of common law countries, the principles of incorporation hold. It's about realising children's rights. It's a progressive agenda, but it is legally possible. The Human Rights Act provides a good model, but not the only model. And I think some of the things that Tam's been speaking about, particularly in relation to Article 3, best interests, and Article 12, the right to express views, are certainly principles that could be incorporated for all children into Scots law. I think one of the things where there's been confusion is what we mean by incorporation and whether we mean the direct transposition of the UNCRC into Scots law or whether we mean something else. And I think we're not suggesting, or certainly UNICEF UK and I know Together are not suggesting that you should take this UNCRC completely as written and put it into Scots law. But that we should look at creative drafting to look at where we can build on standards already in Scots law. And certainly the CRC was designed to be a minimum standard. So it's about actually if there are stronger provisions within Scots law, such as best interests being paramount, rather than a primary consideration that those trump the UNCRC. And I think that's quite an important point. I guess the other point in relation to that is that economic, social and cultural rights, which I think is ultimately what some of these discussions come down to, they are substantive rights, they are well-articulated rights. They have been made justiciable in all manner of countries, in all manner of ways, including in UK legislation in the Child Poverty Act, for example. So I think we do have examples where incorporation is possible. You can go all the way in terms of direct incorporation, you can go with principles, you can go with ministerial duties. But I think the challenge right now in Scotland and also wider in Wales, but also in the UK, is about taking a completely non-legal approach to implementing children's rights means that you get gaps. Some children only have access to certain rights in certain settings, things get missed. And I think that's an issue going forward for children in Scotland.
Alan.
Yes, very briefly, because I do know you want to move on, but just to answer the direct question, there are different models of incorporation around the world. The best practice and the most sort of modern trend of incorporation is giving constitutional protection to these international human rights treaties. You can incorporate in other less effective ways through specific legislation or administrative means, but giving constitutional status is regarded as the modern best practice. What that means in Scotland, pre and post referendum, is really where we are at. If it's devolution, then one way would be giving status to the UNCRC and other international human rights treaty obligations to the Scotland Act, or writing into a piece of legislation like this that the overarching framework and direction should be implementation of the UNCRC.
So we can't do that though. We can't put that into the Scotland Act. That would
No,
have to be a UK government.
that's right.
Yes,
that's right. Were it to be an independent Scotland, then you would have it as part of a written constitution.
Right. Okay, thank you. I'm sure you're very keen to talk, but I mean, I'm sure that's probably covered it, hasn't it?
I'll pass on it.
Thank you very much for that. I want to move on because we have got a number of areas we want to cover, as I said earlier. Colin Beattie.
Thank you. I'd like to go to that part of the bill that enables the Children's Commissioner to investigate individual complaints. One of the first things that jumps out here is that there's an assumption in the financial memorandum that there would be between 1 and 4 investigations a year, and that this would require 3 extra staff and £160,000. You know, as a layman, that seems an awful lot of money. Is that in line with what other bodies require for individual investigations?
Yeah, that's if that was the only power that is being introduced. In fact, there are 2 powers that have been introduced in terms of the Children's Commissioner. The first one is a power of investigation, which is the 1 to 4 estimate, which the government policy, the financial memorandum has said is speculative. But underneath that, there is a power to investigate without recourse to formal investigation, below the power of formal investigation. Now, in my estimation, that will be hundreds of cases. And I'm saying that from the experience of my office not having an investigatory power, and yet we get hundreds of inquiries, many of which could be regarded as complaints that under the new arrangements. So in fact, even if there was only 1 to 4 formal investigations using the full powers of investigation, there's another section in the proposed legislation which is the handling of individual complaints, and you only need to look at our complaint scrutiny handling bodies in terms of the number of complaints that they handle, and that's my estimation of where the major resource implications will be for the office. It's in those hundreds of complaints that will come in which are stopped short and can be dealt with by way of not going for full investigation.
Would 3 extra staff handle hundreds of investigations?
Well, I've been in discussion with the Scottish Government with regard to the actual resources that would be required on that. And I'm reassured by some of the measures that the Government are saying in reviewing the IT requirements and reviewing the staffing requirements. There's a certain amount of estimating going on, but it would be wrong to look at the additional resources to the Commissioner's office just through that lens of formal investigations. The main impact is going to come from those cases that come to the office as a result of complaints being made that don't require full investigation.
Looking at the complaints, under the proposed new powers, the Commissioner will in fact only have powers of recommendation. How is that going to work?
Yeah, that's powers of recommendation in terms of full investigation. My approach is that really, I mean, the first thing is that a scrutiny landscape, if you ask any of the scrutiny bodies, that there's an absence of children and young people taking complaints. So that's the first thing. And I think that it'd be my responsibility to actually build on the work that we've already had about direct contact with children and young people. This isn't going to be an investigatory power which is the power of last resort. This is going to be about early resolution so that we actually improve children's situations without having recourse to go through formal complaints procedures. So in the majority of instances, I would expect to be liaising back to local areas, local public bodies, the very point that I made earlier, because they are the people, they are the authorities who will make children's lives, who improve children's lives. So it's actually not going to be just focused on that investigation.
But you feel having the power to make recommendations is sufficient?
Yeah, I mean, recommendations at present, I think that if that's how we conduct a full investigation, yeah, I would expect recommendations to be made with timescales for review, the opportunity for public bodies to report back on how well or what action they've taken as a result of the recommendations made. I wouldn't want to put it stronger than that, but in the majority of instances, this will be about early resolution by agreement.
The bill doesn't allow the Commissioner to investigate issues which could be investigated by somebody else. Yeah. Can you give some examples of how that would arise?
Yeah, I mean, that's already in the existing power. And in fact, I've been encouraged by the discussions that have been facilitated by Scottish Government with the other scrutiny bodies. If you look at the power, the way that the power is framed, it's where rights, views and interests haven't been properly taken into account. That's a very wide-ranging scope of responsibility, and part of the responsibility on me as a result of the powers, if they're agreed through Parliament, will be to narrow that down so that it makes sense to children and young people, and that it makes sense in terms of that quite complicated scrutiny landscape.
One area which there's potential for overlap is with the Scottish Public Services Ombudsman, and you know, a quote from them, they say, "It's not immediately clear from the legislation where the boundaries between their and our role will be." Now, obviously, they cover the public sector, but the Commissioner also covers the voluntary and private sector as well.
Yeah.
How would you see these sort of overlaps being resolved?
We're in active discussion with the Scottish Public Service Ombudsperson right now and the other scrutiny bodies to make sure that it's neither too wide so that it becomes unmanageable for the office, nor too narrow, that it doesn't actually perform the redress that the Scottish Government have stated in their framing of the particular powers that are in the bill right now.
Just on a general basis, do you know of cases that you would have wished to have followed up that you haven't been able to?
Yes. There are several instances where cases come into the office and I tentatively send probing letters to those concerned, but knowing full well I don't actually have power of investigation as it stands right now. But we have to respond to those, and I have to respond to them because often people come with legitimate concerns where they feel that the rights of the child or rights of the children of which they're concerned haven't actually been taken into account. And I can say right now, I mean, it does get a response. It does actually get a response at local level. I think I could take that further if there was an investigatory power. And in fact, in terms of the complaint handling, I'm looking at early resolution. I don't want complaints to be routinely coming up to the Commissioner when they could and should be dealt with at local level.
Thank you. Can I just push you a little bit, Tam, on some of that? You said at the beginning of that line of questioning that you would expect there to be hundreds of complaints that you might want to look at.
That may come to the office.
That may come to the office. Well, I'm trying to get to the nub of this because clearly the legislation is quite clear. I've got it in front of me, and you will know it very well as it's drafted, that you cannot investigate an issue which could be investigated by someone else. It's in 5(2)(a), or 2(2)(a). So I'm just trying to figure out, you know, if you could give me some specific examples of those cases that you're thinking about that could not be investigated by somebody else.
I mean, if you look at the public service ombudsperson, they look at process. So much of their consideration is whether proper processes have been followed, you know, in terms of looking at a complaint. I think I would get in at a stage earlier where there's legitimate complaints that children may make. For instance, take the example that I gave right at the top of my evidence in terms of children leaving care at too early an age, who are then out of the care system, but feel, in fact, that they are of an age where they should be provided with additional support, should be provided even with additional care placements. And in fact, the committee's got that under consideration right now with the leaving care proposals. So that's the kind of instance where I would be considering whether there was a role for the Commissioner in terms of the full investigation.
Yeah, I'm trying to think, under what powers would you effectively, not you wouldn't do anything, but effectively, if a young person leaves care, no matter what we think about the age they leave care at the moment, under the current rules, once they leave care, the rules are pretty clear. I mean, they can ask for help, and that is assessed by a local authority, etc. I mean, what's your role in there?
Well, if they're still 16, 17 and they leave care and they subsequently become homeless, then it's arguable that there are ongoing responsibilities of the local authority. But right now, those young people languish in those particular placements. We don't actually revisit children and young people, or young people who are in that position. Now, you were asking for an example on it.
Yeah, I'm just wondering whether that, I mean, is that not the role, for example, of somebody else? There's nobody else who would be involved in that?
I'm not aware of anybody else picking those up right now.
Yeah, and if that is the case, that's an example of one, and I'm not sure if it is, but if it is, and nobody else is investigating it, what would be the purpose of your investigation? What would be the outcome you would expect of that investigation? Because clearly under the rules, nothing had gone wrong in the sense that those are the rules. Yeah,
I come back to the different levels of powers. You only elevate it to the level of investigation in exceptional instances. Most of this is actually about resolution at early stage. So given early notice of it and the speed to be able to respond to it, you could get in at that earlier stage without taking it through formal investigation.
Okay, so let's go back to the beginning. We'll go round in a circle here, but okay, so what is this formal investigation? What are these specific examples of formal investigations that you would undertake that nobody else could undertake?
I think the criteria, we're still developing those criteria because it's where there are serious breaches of children's rights, where it's of such significance that it would have an impact on the practice of public bodies generally. And in all likelihood, those will be the cases that will have gone through other complaints processes, because my objective is to make sure that complaints processes at local level are used when and, if possible, at the earliest possible stage.
Given that's your definition of what you would investigate, and I think that's probably correct, I would agree with you there, then that sounds like there'd be a very small number.
Yes, and well, it's still speculative just now about whether that's 1 to 4, but those are the formal investigations. Those are not the complaints, because it's the complaints that will either be resolved at an early time or be elevated to full investigation. So there's still some working out to be done in that. I've given you a very rough outline of the kind of criteria that I would be looking at in terms of formal investigation, but the key thing is that the bulk of the work that will take place under this individual complaint handling is exactly that, individual complaints that are not elevated to full investigatory power.
Okay, thank you. Liam, did you have a supplementary?
Yeah, just on the similar theme, my understanding is that with referrals of complaints to, for example, the Ombudsman, there has to be a demonstration that all local avenues have been exhausted. From what you're saying in terms of the early intervention, early resolution, that isn't going to be a requirement on any complaint that's brought to the Commissioner in the future.
Yeah, I think that because there's a time and place and there's a need to act speedily with complaints from children and young people, it would not be best, it wouldn't be the best approach that they have to have exhausted all local complaints processes. Now, it may be that in a very high number of cases I'll be referring back to those local complaints processes, but to set it as a criteria, I don't think would assist the children and young people who would be wishing to make complaints and wishing the Commissioner to actually handle
but does that not run the risk that those local avenues will be then routinely circumvented? I mean, the reason is, I mean, I suspect the Ombudsman likewise would say a degree of early intervention may have helped us getting to the extent that it was by the time it reached me, but for good and sound reasons, those local avenues do need to be exhausted before it comes to me for me to be able to execute my responsibilities.
The answer is no, it's because of the judgment now that the office will be exercising, and I've already stated several times about referral back, signposting back to existing complaints processes, and that's actually my preferred option. I've been going round the local authorities to discuss the operation of this. I have to say I'm encouraged in the main about their response in terms of how we will set this up. We've got some time between now and the actual enactment of the bill to look at the detail of how wide the scope would be, how we interpret it, how it would sit with the other investigatory bodies. Memorandums of understanding, I think, will form the basis of a relationship with those bodies, and it will be about being clear in terms of how we manage to look at cases which shouldn't or haven't been dealt with at a local area. My preference definitely is to facilitate the use of local complaints processes.
So you don't think there is a risk that in a sense you will be intercepting processes that otherwise would fall to the Ombudsman, or indeed subsequently may act as a point of contact for those who have exhausted the line of inquiry with the Ombudsman and are looking to challenge the funding?
No, I don't want to create another layer of complaint handling. I'm interested in resolution for children and young people at the earliest stage. And you're right, there is a judgment to be exercised so that this doesn't become a power that's seen to be exercised in a meddlesome way. And that's why I go back to what I said earlier about making sure that this is referred back to local level, because those are the places where these changes, where these improvements can be made in children's lives.
Can I, sorry, I want to pick up on this because I'm still not clear. Are you saying that, could you use the words, it would be a judgment and it would be your preference? Are you saying that you have the right to decide whether or not you intervene in these cases at an early stage? Because that's not the case with other bodies who investigate these things. They automatically send the case back if it hasn't gone through the proper and full process.
Yeah, The way that the bill's framed at present, it gives discretion to the Office of the Commissioner. I'm saying that I'll exercise careful judgment on how that's actually
So you'll have that discretion. How does that impact then on, if you took up a case at an early stage because you decided that that was the right thing to do rather than refer it back through the full process, and then you investigated it, it then went through whatever process.
Case handled it rather at that
well,
early
okay,
stage.
not investigated it.
Okay.
You were involved in it, shall
Yeah.
I say? And then at the end of the day, it then came back to you as a formal complaint for investigation.
Yeah.
Where does that leave you? Because effectively you've looked at it at an earlier stage, and then you'll be looking at it again at a later stage.
Yeah, that's a fair point. And in fact, in the setting up the whole complaints function, I have to look at that particular possibility because that's quite a tricky process. But remember, I mean, we're looking at it just now and we've got the opportunity through the process of enactment, but it's a fair point and one which I need to actually attend to in the setting up of how this function would operate, so that you don't compromise the
indeed.
formal investigation.
Yes,
absolutely.
It's effectively for your own protection in terms of
No,
that.
I agree. I agree.
Thank you very much. George Adam.
Thank you, Convener. Good morning. I would like to ask about named person and information sharing. It's one of the issues that came up. Last week we had Highland Council, Bill Alexander, and he mentioned the model that they work up there and how the things, as a practitioner, things have moved on dramatically for him with the model they now use, in so much as that they can get information and proactively deal with children and young people's issues. Now, Section 26 requires that service providers and relevant authorities provide information to a service provider they consider might be relevant to the exercise of the named person function. My question is, are the provisions on information sharing needed in order to ensure that the named person service works properly?
I'll start somewhere else, Tam, if you don't mind. After, I'll give you a rest. Juliet.
I'm afraid I won't be very good at answering your questions because this is something that we've been debating among Together's membership, and there's certainly very mixed perspectives about whether the provisions are actually needed, whether sections 26 and 27 are needed, or whether it's possible for the named person function to operate effectively within the current information sharing parameters. We don't have, as a membership organisation, we don't have a consistent view among our memberships on whether we do need sections 26 and 27 or whether robust and clear and concise guidance would fulfil the role instead. The one thing that we really do agree on, we think it's absolutely essential, is that we do need to get the balance right between the child's rights to privacy and the need to share information. And we also need to ensure that we do consider the best interests of the child. And whatever information sharing provisions are introduced through this bill, it really must ensure that practitioners are able to make clear, good judgments about when to share information and also when to act on that information when it's shared. So we must make sure that any information sharing is appropriate, that it's relevant, and that it is in the best interests of the child. And I'm afraid we don't have an exact position on whether sections 26 and 27 are needed. There is agreement that as it stands at the moment, the sections 26 and 27 aren't very precise, they aren't very clear, and they would certainly need a change of wording if they are going to be included within the bill.
Sam.
I think I would concur with all of that and just simply add that the right to privacy, whether it's under the ECHR and Human Rights Act or under the UNCLC for children, is really important in terms of their confidence of approaching services when they have a problem in their lives. And one of the things that it feels is missing from the bill, if it is indeed necessary to lower the threshold from significant harm to concern about well-being, is that there's an issue of informed consent, and particularly in terms of children, so that they know where that information is going, what it will be used for, and where it will end up. And I think that's a principle that really needs to be at the heart of any child rights approach to looking at information sharing.
Alan.
Thanks. I think one of the advantages, slightly going back to the discussion we had earlier about having an overarching framework, rights-based, is very, very relevant here, because the named persons provisions, both in terms of the information sharing and any intervention itself by a named person, unless it is consistent with the existing human rights framework we have, it does have the potential of interfering both with the rights of parents and the rights of the child, unless the element of proportionality is used, which is what is required under the Human Rights Act, so that this legislation needs to be interpreted and applied in a way that's consistent with the right to respect for private and family life, which governs information sharing, governs state intervention into family life. So it could be clearer, and one would hope that with training and guidance, that connection between this bill and the existing framework of the European Convention on Human Rights, let alone the UNCRC and the discussion we had earlier, but the lack of that clear recognition of the framework in which this bill sits understandably gives rise to some concerns. It can be made to work, but it be made to work most effectively if more explicit references were made to the existing law of any intervention or information sharing must be done where it's proportionate, i.e. the minimum necessary to achieve the aim, whether it's preventing harm to the child or the privacy of the child or indeed of the parents. So more explicit guidance certainly needs to be given, if not in the bill, preferably and certainly in training, guidance, best practice, etc.
Sorry, just can I clarify something? The Information Commissioner obviously earlier this year in March stated that effectively, talking about on the same lines as you said, proportionate sharing of information is unlikely to constitute a breach of the Data Protection Act in such circumstances. Yeah. So clearly, and what that was referring to was that there is a risk to a child or young person that may lead to harm. In other words, it wasn't that the harm was actually happening, but it may lead to harm. Yeah. So clearly this is at the kind of well-being point in the cycle, if you like, that the Information Commissioner seems to think that as long as it's proportionate, this is a reasonable thing to do. You would agree with that? Yes, but I think if that were more clearly understood and shared by practitioners, that they didn't think there was some distinction between what this bill was trying to do and where the threshold was and what I'm saying an Information Commissioner is saying, there has to be more coherence to it. Okay. Thank you. Tam.
I support named person. It's not perfect. They have to look at named person for 3 to 4 year olds, where the children spend the majority of the time, or a lot of the time, in nursery provision through private or partnership or state, so that has to be looked at. But the key point there is about the resources for health visitors. And that's not about whether they can carry out the function of named person or not, it's whether they can actually carry out the function of being a health visitor. And the government have chosen to overmap that with named person. So I endorsed the previous evidence that you've received from Royal College of Nurses and others with regard to the need, the urgent need for us to do something about health visiting. But in principle, I absolutely support named person. I want to make a comment really about the way that Section 26 is framed, because you've rightly made the point, Convener, about it being about well-being. Well-being, which we define as safe, healthy, active, nurtured, achieving.
You better just say really. Yeah.
Respected, responsible and included there. That's very wide. And the way that the duty is framed right now is if it might be relevant, they ought to share. Mm. Now, that is a very, very wide, and it's a very wide scope, and it's a significant shift from where there's a risk of harm. And so, therefore, I think you may be advised to look at amendments in stage 2 about how specific that wording might be, particularly might, because to me, that reads as if there's virtually no information that you wouldn't share just in case it might, and yet there's a responsibility that you ought to share it. So I think that's where you need to, I think there's the potential to tighten up the legislation so that it becomes actually proportionate rather than as it sits just now, which I think is disproportionate to the intention. And the intention is well-intentioned because we want to try and capture those children whose well-being has been compromised, who in fact are living in neglectful situations. That's exactly what we want to do. but not to have too much information. If I just take that, we do have examples of where too much information actually causes difficulty. And through the 2000s, we had a year-on-year increase in referrals to the Scottish Children Reported Administration, mainly on the back of domestic abuse incidents where the police were automatically referring children who were involved in those. And it almost brought our system to its knees. And in fact, what you heard last week in terms of the better management of that is pre-referral screening to try and sort out those children who we are genuinely concerned about rather than those who are just caught in the system. And I think we need to give very serious consideration to this. I agree with an increase in information sharing, but it has to be proportionate to the objective of what we're trying to achieve.
Okay. George.
Yes, I'm a practical man. I'm trying to get how we can make this work in the real world out there. And as far as I'm saying, with the evidence that came before us, Bill Alexander was the one that was telling us how they worked it within Highland and how it worked for them as a system. With the named person, the only issue they seemed to have was when it wasn't actually enacted, because once people understood what it was about, what it could offer, people that were involved in the process actually saw it in a positive light. And the other thing that he mentioned was the fact that the whole system was based on the GIRFEC principles, and that their information sharing was done with best practice with the Information Commissioner's ideals. So with all that in mind, you know, is that not a practical, sensible, successful way for the model to go forward?
Yeah, and remember that Highland have been developing this model over 10 years. They've done it in the absence of legislation. So if we are to try and have consistent practice across Scotland, which I understand, then we have to be very clear about what we put in as duties and how those duties will be enacted. And I'm already flagging up, I think you might want to look at some amendments in terms of the precise wording of section 26, which will have the same intention, or would have I think, a much more proportionate impact on people at local level. So.
Can I just, before I bring Liam in, you're saying that you think it's not, well, I think you said it's disproportionate, I think is the word you used, when you were referring to section 26 and 26.2a, where it says it might be relevant. 26.4, A, B and C, defines what information falls within the subsection if the information holder considers that, and then it goes on to describe and define how that would operate. You don't think that's sufficient?
I would prefer, we're in stage 2 debate just now, I would prefer if it said under section 26.2, which is relevant or is considered relevant, and that actually tightens it. And remember, you're putting duties on people where they ought to share. So you want to be as clear as possible, particularly since the definition is that of Shinari, which is a very wide-ranging definition. The intention's still the same. It's to try and make sure that we capture those children of whom we're concerned about, who currently the sharing information is not there. But I think that you really, and it's a stage 2 debate.
I'm concerned about if you tighten up in the way you suggest, that effectively we don't make the progress that we all want to make.
Well, I think that's a matter for debate. You're going to have to, as it sits at present, you're going to have to be very clear in the guidance as to exactly what are those pieces of information that ought to be shared and those that are not. And my understanding of Shinari is it's actually a very wide-ranging, deliberately wide-ranging definition of well-being for our children.
Liam.
Yeah, just following up on that, I mean, you've talked about the risk associated with the kind of broad terms of Shinari. Obviously, the other element here is the lack of consent in terms of the information sharing. I mean, is there a risk here that where consent really shouldn't be a factor, where there is perhaps a risk of harm? The bill casts a degree of doubt around information sharing generally, and therefore people aren't making a distinction between welfare, if you like, and well-being, which poses problems. I mean, I think the point you made in relation to Bill Alexander's evidence is very pertinent, in that they're operating in an environment pre this bill, but when you start putting stuff into legislation, it becomes a bit clunky, and it's rather a blunt instrument, so we have to get this right. Is there a risk around that issue of consent, that it bleeds into the issue of welfare?
Well, you have to carry parents with you, and it's principally parents that you're talking about in terms of when the information is shared by and large, good practice would be that they're aware of it, that it's consensual, and that people know exactly what's happening. I think you would need to build that into your guidance, given you're going to potentially have such a wide scope of information sharing. I don't think that's really the intention, but my reading of it just now is that that could be the impact of it. So I think you would avoid some of those difficulties of having too much information shared across if you actually start narrowing it down.
Could you envisage any circumstances where, I mean, in terms of welfare, I think it's very easy to see where you wouldn't necessarily want to go down the route of securing consent. In well-being, I struggle to see the cases where that might be relevant. Are you? Can you help me?
I would go back to what you're going to put on the face of the bill and the expectations of the officers or the workers who are actually responsible for trying to interpret what is it that they ought to share. And just another example, it's not so much the sharing of information, it's about what you do with that information. So you only have to look at the Western Isles report, where information was shared time and time and time again, but not acted upon. So as you're looking at the guidance, there has to be a purpose in terms of the sharing of information and an expectation that there would be some action that flows from that. So just to focus on the information sharing per se may neglect some of the key things, which is what you want is more informed action in terms of children whose well-being, if we use the terms, may be compromised.
Thank you very much. Claire Adamson.
Thank you, Convener. I'd like to ask a little bit about children's rights and getting it right for every child. Given that GIFIC is going to be put in statute as a result of the bill, the government has produced a recent report in which they state that GIFIC approach has been built up from UNCRC, accordingly ensuring that the approach applies in the way public services operate will put the UNCRC into practice for each child. And they've done quite a comprehensive mapping of Shinari within the GIFIC principles and the UNCRC. So I would just like your opinion, if you agree with the government's position on this, and give it, if you could go further and say what is missing in the rights perspective for what they've stated about GIFIC at this stage.
Alan, if you don't mind.
Right, I thought that was directly to Tam, but
yes, but I'm sure he'll contribute in a moment.
I think Tam may answer more of the specifics about that, but more broadly, I think there is a lack of consistency between different parts of the bill. And if you take the earlier discussion about the investigative and complaint handling powers given to SCIP, the Section 1 duty, and the talk about UNCRC, that parts of the bill are talking about well-being and the named persons and the plans. Other parts of the bill are talking about the duty on Scottish ministers. Other part of the bill is talking about SCIP being given power to take into account the rights, views and interests of the child. There's no consistency. And I think that's the concern that the Human Rights Commission has, whether it's looking at the sharing of information or the intervention, or how Tam and his colleagues go about using the powers that they're being given, when you can only really best use these powers in the shadow of what the law is. And if you don't have the law which enshrines the rights, views and interests of the child, then that will impact upon the effectiveness by which you can take complaints or carry out investigations. So I think there needs to be greater consistency throughout all these different parts of the bill. And that's what we said at the outset. If we had a more explicit reference to the UNCRC and to the existing human rights framework provided by the Human Rights Act and the European Convention, then a lot of these inconsistencies would be able to be reconciled in a way that made it a much more effective bill and led to better outcomes for children.
Thanks. Sam.
I think just building on that, one of the realities for children is that rights really come into their own at a local level in their day-to-day lives. So one of the things we were quite disappointed to not see in the bill was a duty on public authorities to act to implement the UNCRC, so reflecting that duty that's been proposed for ministers. I think there is a reporting duty on public authorities in relation to the UNCRC, which is very welcome. But it is limited in that it doesn't require an action. And while one would hope that best practice and the implementation of GERFEC would achieve that, unfortunately it is our experience and that of others that that isn't always the case. I think one of the reasons for the lack of a child rights framework permeating the whole bill is the nature of the original two bills being merged into one. I think there are some very obvious points within Part 3 of the bill where you could begin to build that child rights framework at a local level that would really support the full rollout of GERFEC across Scotland. Whether that's placing children and young people on the face of the bill as people who explicitly need to be consulted when children's services are being planned throughout the local area, or whether there's an explicit requirement to consult a child on the content of their individual plan.
Juliet?
I'd certainly echo what Alan and Sam would say, have said. And in terms of Together's perspective, we really do believe that there is so much scope for greater consistency and coherence across the different parts of the bill. And I think that's missing as a result of the fact that I think rather than GERFEC actually coming from the UN Convention, I think in the document that you referred to, Jane Oldgate's research, it shows what GERFEC is and then maps the convention into it, rather than having the convention as an overarching framework for children's rights that then GERFEC's underpinned by. So it's a bit of a back to front exercise. And I think that that's why the bill does lack this coherence. I mean, certainly there's a lot of scope within Part 3, and we welcome the duties around children's services planning. But those are all framed around well-being, and the aims of a children's services plan are around well-being. And we feel that while Part 1 of the bill is concentrating on children's rights, really Part 3 of the bill, which is about delivery, as Sam says, certainly the delivery of services that really day-to-day have more of an impact on children's lives, they're underpinned by well-being. And so we do think that there's scope to really bring the rights duties into Part 3 of the bill so that children's services planning is underpinned by rights and well-being. And this way we will have the coherence between the ambitions of GERFEC and in promoting children's well-being and the principles that are enshrined in the UNCRC around children's rights. And we think that certainly at stage 2 there's a lot of scope for amendments to look at rights and well-being and about bringing them together and ensuring that all elements of the bill, from the aims of children's services planning, the aims of named person, are underpinned by rights as well as well-being.
Okay. In many, many instances, children's rights are realised in Scotland. So you can actually put documents together that say, here's where the rights have been realised. But in too many instances, they're not. And I would go back to point us towards Part 1, where there's a requirement in terms of the production of reports on public bodies as to the steps that they've taken to better realise children's rights. I think that you could improve on that by actually having some action that as a result, rather than just being a reporting requirement. In that way, you will get some of the consistency that people have talked about. In that way, you will actually have a marrying up of ministerial duties and duties at local level, because it's at local level that this really counts. And I think that that would be one of the strong recommendations that I would give to the committee, to look at the place of public bodies in the ambitions that have been laid out in the bill about Scotland being the best place in the world for children to grow up.
Thank you. Thank you very much. Can I thank the witnesses for their evidence this morning. It's been very interesting indeed. A lot of issues we've covered, but I do appreciate you taking the time to come to the committee and give us your views. Our final evidence-taking session on the bill will be next Tuesday, when we will hear from the Minister for Children and Young People. And I'm sure many of the issues that have been raised today and raised through other oral evidence sessions, and in particularly all of the submissions we've received in writing, will be put to the Minister next week. So can I thank everybody who's given oral evidence and written evidence at this stage for their contribution to our work. And I wish to briefly suspend the meeting now before we move to the next item of business. Thank you. Our third item this morning is to take evidence on the Scottish Government's 2014-15 draft budget. We have agreed to focus our scrutiny on the Scottish Government's youth employability commitments, funding for these, and how the policy focus on younger learners is impacting on lifelong learning. Can I welcome to the committee this morning John Henderson, Chief Executive Colleges Scotland, Lawrence Hibbles, Interim Chief Executive Scottish Funding Council, and Gordon McGuinness, Head of Industry and Enterprise Network Skills Development Scotland. Good morning to you all, gentlemen. Before I move to questions from other members, if I could just ask you a kind of general question. The Government's made a number of, various commitments on youth employability. And we'll get into the detail of those as we get into some of the questioning. But I just wondered if it would be useful if you could set the scene for those commitments by briefly outlining the progress that's been made in helping deliver those commitments and the progress that still has to be made by each of your individual organisations or bodies. Gordon, can I start with you?
Okay, thank you. Thanks for the invite along this morning. I think we're working hard primarily around our modern apprenticeship programme. Delivered 25,000 plus last year, and that's our target for this year as well, and the vast majority of those are for young peoples between 16 and 24. Programmes working well, good success rate in terms of sustainability into employment, and that's something we see building further on that. We've changed our employability fund and went to a kind of co-commissioning model, so we've taken a number of our initiatives like training for work and get ready for work and put that into a common fund, and we've co-commissioned that along with the local authority or employability partners. And that's early days in terms of the change in the programme, but initial results seem positive, and again a strong focus on progression and into sustainable employment. We work heavily with our local authority partners in terms of the Youth Employability Scotland Fund, the wage subsidy programme, and again we're heavily involved in the promotion of that activity. We do that through a combined website called Skills Force, and the primary focus for that is for employers, so they can understand the offers that are there, both from national organisations like ourselves and Job Centre Plus, but also local authorities, and a number of them have allocated additional funds for wage subsidy and additional support measures to get young people back to work. I think things have went pretty well, but obviously it's still a very challenging economic climate. There's still a large number of employers that would like to see commit to recruit young people, and part of the work that we've done through the Scottish Skills Planning Model, which was referenced within the submission, highlights, and particularly the work we're doing across sectors, highlight some of the demographic challenges that some aspects of businesses are facing. And therefore we're encouraging more employers to commit to recruit and develop young people to give them business continuity and sustainability.
Thank you very much. Lawrence.
Yes, thanks also for inviting me this morning. Our main actions in support of all the government policies are through the outcome agreements that we negotiate with the universities and colleges. And that process, as you know, is now 2 years old, heading into its third year. We place expectations on the colleges and universities as what they address in their outcome agreements, and we negotiate with them improvements. So, for example, colleges are expected to set out in their outcome agreements their part, along with other partners, in delivering opportunities for all. They're expected to plan the curriculum in partnership with taking into account the needs of local employers, taking into account the local demographic of their area. They're expected to dovetail their provision with other partners, and they're expected to increase success rates and reflect improved quality of provision in their targets they set for themselves. So, for example, we've seen in the recent set of outcome agreements a shift towards provision for young people. Across the whole of Scotland, it's around 70% of all provision is focused on young people, and that's reflecting the priority we've got at the moment. That varies for different regions because, quite rightly, the agreements we strike with individual regions are different depending on their different circumstances. I just very briefly mention our role in relation to the universities, because of course they have a similar impact, though they're not quite so direct for this particular target group. And our expectations of the universities cover their roles in terms of widening access. And here it's particularly important to mention the extra impetus we've given to schemes for 2+2, 1+3 arrangements with colleges, whereby young people or people can start on HNC and then seamlessly progress to a degree level provision, and we've provided an extra 1,000 places in that area for going forward. I think overall we're on a journey with outcome agreements, which essentially articulate what will be provided in return for the funding that universities and colleges provide. And I look forward to the set of agreements that we're going to negotiate during the autumn, where I think we've got common agreement about the structure, what they should contain, and the ambition that they should express.
John.
Well, thank you for the invitation. It's clearly very important to colleges to respond to the needs of young people. It is a huge problem in Scotland, as we know, high youth unemployment, and colleges are very much at the forefront of giving these young people the skills to give them the opportunity to move into the labour market. There has, as Lawrence said, been a refocusing of college activity. This has been due, of course, to government steer, but it's also been due, of course, to the funding constraint that colleges has been under. Choices have had to be made, and young people have been prioritised, and there has been a price that has been paid in terms of lifelong learning and adult learners going to colleges. No doubt we'll get on to talk about that. But the colleges are delivering, as been asked to do through the regional outcome agreements, and they are preparing these young people. As Lawrence has said, 70% of activity now in colleges focused is on these young people. But as I say, that's taking place against a backdrop of deep cuts over recent years in college budgets, and there is a consequence in terms of other learners. The other thing that I'd like to mention in the context here is the huge structural change that colleges are going through. They have kept their eye on the ball in terms of delivery for these young people, despite that huge structural reform that's very successfully been carried through as well. That's been a huge challenge for colleges, but I think it's a great success as well.
Thank you very much. We're going to come on to a number of areas that are concerned to members. Start with Claire Adamson.
Thank you, Convener. I would like to concentrate on youth unemployment. And I think that's the right thing, that the government has a focus in that area at the moment. And as a member of the European External Relations Committee as well, I'm very aware of how big a challenge this is across Europe, not just in this country. But in the budget in 2014, there are cuts to the EMA, to the post-16 transition towards employment. And I just wondered what impact you thought that might have on going forward in tackling youth unemployment.
Who wants to start? Who wants to say anything? Gordon, sorry, my eyes rested on you, Gordon.
Yeah, so. No, it's okay, it's fine. Those initiatives, I note that the budget cuts are not directly in areas that directly impact on ourselves. And I think we probably take the view that, one, we're trying to deliver greater efficiency in terms of the reach of our service, just in terms of how our staff deliver. But I think we recognise where we are in terms of public service funding, and that financial constraints are tight. We've sought to make best use of the funds that are available to us directly, but also to work in partnership with others like the third sector and others to try and make our own resources go that bit further. But in relation to EMA and others, it's not something that's directly impacting on SDS at this stage.
Sir John?
I suppose for our main concern is in relation to the college funding and the student support funding that we provide. As we've said before, it's good news that the college budget stabilised in cash terms. So from our point of view, that enables there to be provision. It's worth mentioning on the student support side, which is kind of next to the EMA question, that for 13-14 we were pleased that we were able to increase the rates per head of that funding. I'm not aware of the detail of the EMA funding, I have to say. I apologise for not having an answer to that one.
Just kind of general picking up, I think, on that kind of transition of young people into college and into the labour market. I think the interim report from the Wood Commission is hugely important, and it's got a great potential for improvement in that area. It seems to me that we have kind of taken our eye off that ball a little bit, where young people and colleges working together in partnerships. The numbers, for example, in my paper show quite a fall in that college-school partnerships. Would very much welcome, I think, we can deal with that if we have the resources available to deal with that in that partnership, to make that transition less of a kind of cliff. And I think if you can get used to students at school going to college for part of the time and vice versa, I think you've got a much smoother transition between school and college, and then into preparing for the labour market as well. I don't have the detail in EMAs, but I think it is fair to give credit to the Scottish Government that we still have an EMA system in Scotland. And in terms of looking at the numbers of young people coming through into the college system, it would seem that despite restraints on funding, that's not proving a disincentive to actually come to college.
Okay, thank you very much. Neil.
Thanks, Convener. Given the focus on provision for 16 to 19-year-olds, particularly in colleges, why do you think the number of young men not in education, employment and training increased from 14.7% to 14.9%, and the number of young women not in education, employment training increased from 10.1% to 11.7% in 2012-13? Just anyone, I mean, it's for all three of you actually. But
I think the numbers will vary just in terms of labour market performance. I think in general terms, certainly compared to a UK level, I think we've made good progress north of the border. We see obviously regional variations as well in terms of that unemployment level, and that's where we would seek to work and deploy our resources in terms of addressing those regional disparities. But I mean, it's subject to the labour market rising and falling as well. In general terms, I think we've made reasonable progress in very challenging economic circumstances.
I think that's right. It's the difficult economic circumstances and the challenges that face young people, which leads you to more need for more and better provision. And I think the things that John was talking about, as improving the connection between schools and colleges, and with SDS improving the guidance and advice that we offer to young people about how they take their lives forward, is the key to that. I think that does also point to the need for us to continue to focus resources on that group and maybe be more inventive in the future about the kinds of provision that's available. And as John said, maybe the Wood Commission ideas have got some things to offer in that field.
I might speculate a little bit. I don't have any evidence for this, but I think because of the changes in the labour market, there's more service level jobs, higher level jobs, particularly in the service level. I think perhaps young men are finding it more difficult to get entry-level jobs into the labour market. I think the Wood Commission idea of introducing younger people to vocational skills may be more motivational for young males than females. I don't know, I'm simply speculating that there could be more of a problem for young men with low skills entering the labour market than there is for girls.
I mean, obviously the number not in education, employment training has gone up in spite of the focus on 16 to 19-year-olds. So it kind of, I'm not sure it's fully down to the labour market statistics, but I take your point. My question following that would then be, well, if it's, how do we measure the success of opportunities for all in that case? How do we know it's having the required effect if the number of not in education and employment training is going up in spite of this focus? How do we measure the success of it?
I mean, opportunities for all is a broad strategy. It covers, so in terms of how we would measure our SDS performance into that, that's done on a regular basis, reporting back into government on a 6-weekly basis. we measure ourselves against the National Performance Framework, but Opportunities for All as an overall offer covers a whole spectrum of activities, and it's a government offer that is made. From our point of view, we have intensified our support through job coaches, not just within schools, but also those who are in that neat category. And we'd aim to do a follow-up service in all those young people. So, I mean, there is regular contact and an effort to get young people back into active learning and other activities that are going to progress their employability.
It's also worth saying that the agencies work together. We regularly meet with SDS, who track information on students and offer information and advice and guidance. And our key questions is with SDS and the other partners, CPPs and other partners, is to what extent are colleges playing their part in delivering opportunities for all. I think that also does lead us to the questions of the type of provision that's available. And that's one of the reasons why we've broadened or encouraged colleges to offer more work placements as part of their courses. I think, building on John's point, the experience of work and the motivation of work whilst in a learning environment is one that we all recognise as being a good thing in terms of increasing people's motivation and participation.
I honestly don't have any easy answers to this. There's clearly a structural youth unemployment problem as well as an economic recession economic problem. The labour market has changed over the last decade. Young people are finding it more difficult to enter the labour market. All colleges can do in that circumstances, we can't change the labour market. All we can do is try and address it in terms of the adaptability of young people coming through the college system, in terms of the narrow skills we can give them in terms of vocational skills, but also those broader employability skills that one hopes when the economy picks up, they will then be adaptable to go into the labour market. And I think also what colleges are doing in terms of enterprise, preparing young people perhaps for a different type of labour market in the future where they can actually create their own business. And if you look and think of our own daily experiences in dealing with small, medium-sized businesses in Scotland, how many of these people have come through the college system and made a great success of setting up their own business and then going on to employ people. Changing the mindset and helping young people to see that as a route in terms of the future for them. I think colleges have a role to play and are playing a role in giving that enterprising approach through the education system in the colleges.
I would agree with Mr Henderson in that colleges do some fantastic work to help young people back into employment. However, with obviously the budget cuts that we've seen, there are concerns over course provision, a lack of choice. What happens if a young person isn't able to access the course they wish to study? How flexible is this Opportunities for All scheme?
I can answer that, and I'm sure my colleagues will answer as well. The proposition has never been that a young person going to college can do any course they want. There has to be a match between what can be realistically provided and also being realistic in terms of what the labour market in a particular part of Scotland can actually deal with to actually then match that young person to a course provision. So there has to be a kind of a negotiation around that rather than someone saying, I want to do course X, you're not doing it, why can't I do it?
I think it's also important to add to that colleges do work hard to try and match learners onto the right course for them, taking into account their skills, experience, the stage they are in their learning and their ambitions, and also have a duty if somebody's coming to their college for provision that they don't offer or isn't right, to refer them to somebody else who might be better for them to provide that provision.
Just I think from at a local level, we've been working in partnership with our community planning partners and assessing young people as to where they are along that skills and employability pipeline, and looking at the various offers that are available to them from not just ourselves and the local authority, but potentially some of the other voluntary sector partners and the local college. In relation to SDS's contribution into the Opportunities for All, last year, 12-13, we had 12,700 young people through modern apprenticeships and 9,500 through Get Ready for Work in terms of our services. So fairly significant numbers being supported.
Okay, just I follow up just briefly on this area. I mean, the figures for youth unemployment show that youth unemployment in Scotland is lower than it is in the rest of the UK, and employment rate is higher than it is in the rest of the UK. But notwithstanding that, I want to go back to I think that masks a lot of individual differences, the overall figures. And while those figures may be true, the figures that were read out earlier by Mr Bibby, in terms of male and female 16 to 19-year-olds who are not in education, employment or training, well, the male rate has stayed pretty static over the last 2011 to 2012. It's the female rate that's gone up from 10.1% to 11.7%. So the overall increase is not completely, but almost completely in young women. Now, what action do your organisations take to take account of that kind of statistic, that kind of circumstances where, for some reason, male unemployment has stayed, or not in education and employment and training has stayed pretty static, but it's affecting young women more than it is young men. So what actions do you take to address that and try and deal with that?
From our point of view, the key thing would be the negotiations with the colleges about the outcome agreement, and one of the expectations we have of that conversation between my organisation and colleges is looking at local circumstances. And obviously one of the things that's taken into account is the pattern of potential clients, if you like, for the college system, and the gender balance is one of the questions we would ask there. So if we were in a particular part of the country where those statistics were particularly skewed in one direction, we would be asking the college to think about, have you thought about how you adapt your provision to better meet the needs of that local population? And that ongoing dialogue and that ongoing local intelligence, which we might get from the CPP or from national statistics or from other sources, is a thing we would put on the table for that discussion. And I'm confident to say that the colleges are very thoughtful and careful in terms of thinking about how they react and respond to those sorts of changes. The key thing is to put on provision that is attractive to a particular group or that's appropriate for a particular group, and also reflects the needs of potential local employers and the local economy. And that balancing act is one that we and the colleges need to get right together.
Okay. John?
Yeah, I'll just speculate again, and perhaps one of the reasons for the difference in the gender imbalance is because that the male figure's probably been more steady because it's to do with structural difficulties in the labour market. The female figure may well have gone up because of the combination of structural as well as cyclical changes in the economy. So there's been less jobs available because of the economic downturn. It seems to impact proportionately more on females, and that could account for the rise. I'm simply speculating there. I don't know if that is the case. What can the colleges do about that? Well, the colleges can't change the economy. All they can do, as Lawrence has said, is actually prepare these young women for the opportunities that will arise in the future. Now, it's sometimes said that colleges are doing too many hairdressing courses. I don't accept that, actually. I think that we have to be very careful about saying that a particular type of course in a college is the wrong course. That course may well give these young students a whole range of interpersonal skills. It may give them softer skills, and it actually may give them something which is you can't put down on a qualification. It may actually give them a belief and confidence in themselves that they can then go on and do something. And that, I don't think we should underestimate that self-belief that college education can give young people.
Okay, thank you. Do you have anything to add, Gordon?
Yeah, I mean, I think at a local level, whilst it's been a negative change, it's difficult to pick up on those movements at a local level in terms of delivery. That might reflect on the contract reviews of our training providers in terms of, obviously, the retail sector has been through a troublesome time, so there might have been a fallback in recruitment in that area, and we could analyse service and contract performance at that level. For the individuals then, it's about where they access the best service in terms of guidance and training support that's available to them. So that's where we would focus at a local level.
Okay, thank you. I've got Claire Adamson and then Neil Libby again.
Yes, thank you. Mr Bibby introduced the college cuts, and one of the things that was of concern to me as we were going through the changes in the reorganisation of the colleges into regions was the amount of reserves that were sitting in colleges. And it's my understanding that what the Cabinet Secretary was quite clear about was that money shouldn't be sitting in banks. It should be used for delivery of services and used for improving the outcomes for young people. And that was why a cap of, I think, 10% was put on turnover of the amount of reserves that colleges could have. But we took evidence from Professor Gallagher last week, who talked about, I can't remember the exact words, but by and large he said colleges were operating at surpluses, and that they wanted to safeguard and protect those reserves by forming trusts and allios. And I just wondered if you were aware of this and what your comments would be about the reserves being used in that way.
Quite a lot in what you said. I can just try and unpick some of it. I'm sure Lawrence will come in. Reserves in colleges. I think if you look at the latest Audit Scotland report on reserves in colleges, they say that in terms of cash reserves, they're just, in terms of days, slightly over the recommendations from the Funding Council and the cash they should have in the bank. Yes, there are reserves, but these reserves are not profits that aren't then ploughed back into the college, either for capital projects or indeed for meeting some of the costs arising from restructuring. A lot of the costs of restructuring have actually come from the colleges themselves, and I think we should acknowledge that. On the issue of what might happen to reserves in future, and I don't recognise the 10% figure, although there may be something that the Funding Council have up their sleeve I haven't heard about. On the question of what might happen in future, I think this refers to the reclassification of colleges by the Office of National Statistics, which will put them into the public sector in future rather than the private sector. The consequence of that would mean that their ability potentially to accumulate reserves and engage in commercial activity to add to their income, and that commercial activity accounts for some 25% of their overall turnover, is very significant. Now, we are talking to government about ways of allowing the colleges to retain that commercial activity for the benefit of the students in the community. We think a way of doing it is either one or a number of arm's-length trusts, which would be independent of the colleges, but would be able to safeguard the money, which could then not be consolidated into accounts. I'm sorry if I'm getting slightly technical in this, but by keeping them separate, it means that the colleges can still benefit from that and the students and communities benefit. But I do take your general point that, yes, colleges are not in the business of making profits for profit's sake. If they are generating reserves from their commercial activity, that is simply to plough back into the good of their students and communities.
I don't want to add anything to that, but I don't recognise the 10% figure.
You're wrong about that one, so.
I think it did come up, to be fair, isn't it? I mean, I recognise it when you said it, but if it's no longer relevant, then we can just ignore that for just now. We've got a quick supplementary from Neil, and then we'll just move on to the next question.
Just to follow up the question earlier about the number of women and not in employment training or education, and that might be down to, I think Mr Enders said, might be down to the jobs market. Is it not the case that the number of women in the colleges has significantly reduced over the last couple of years as well? So that may be a factor in that figure as well.
What's happened as a result of the budgetary cuts and decisions by government is that college student numbers 25 and above have fallen quite dramatically over recent years, and the more women were engaged in further education in colleges above 25 than men. So these cuts have disproportionately impacted.
Because the question and the figures that we've all been talking about was 16 to 19-year-olds. Yep. So any changes over 25-year-olds cannot be the explanation for the change in 16 to 19-year-olds.
Well, I don't think there has been a change, therefore, in, as far as I'm aware, in under 25s between females and males.
According to some figures in front of me. The number of 16 to 18-year-olds headcount figures in 2008, 2009, 16 to 18-year-olds was 66,353. And in 2011-12, it was 57,592. So it would appear in terms of headcount, there's been a reduction in the number of courses available to 16 to 18-year-olds.
Lawrence? I don't recognise those figures, but if it would be helpful, I'd be happy to go away and do an analysis and provide that to the committee.
The figures are from the Scottish Funding Council InFact database.
Can I just make perhaps again, I don't know if this is actually the case, but can I give an explanation why I think that the two things can be consistent, where I say that actually the numbers, probably in terms of full-time equivalents, have held up, but the actual numbers may have fallen. Because what's been happening is we're seeing more full-time provision in the colleges focused on that, all age groups, in particular on that young age groups, whereas we're seeing a fall in part-time provisions. So the two things can actually both be true. You can have the overall numbers falling, but if you look at it in terms, as the government and the Funding Council do, in terms of full-time equivalents and overall activity, the overall activity could be staying steady. But Lawrence has offered to clarify that.
Okay, thank you very much. So, I want to move on from that area. Colin Beattie.
Thank you, Vera. I'd like to focus a little bit on modern apprenticeships, because they're obviously a key initiative. Seems to be considerable success in delivering the target of 25,000 plus modern apprenticeship starts, and there seems to be a trend of increasing rates of achievement over the past 5 years. However, the figure referred to as a sort of proportion of people who've completed the programme and achieved the requirements attached to it, running at about 79%. What do you do, what steps are taken on completion of a modern apprenticeship to track leaver destinations and follow up where that young person falls under the category of being in need?
Use terminology of 70%, 79%. I would use 77% as achievers and leavers, and I'm not exactly sure of the full.
The figure of 79% came from SDS, by the way.
Okay, apologies. A recent survey showing, I think it's around about 90% are still in employment 6 months after, and I think an important point about the modern apprenticeship programme in Scotland is that everyone is employed status. So they're in a job all through their apprenticeship programme, and the vast majority continue in employment. The numbers that leave can leave for a whole range of circumstances. Obviously 16 to 19-year-olds, as many of them are, may start and decide to do something else after a period of time. Where I think statistics aren't great at measuring it is how much young people have benefited from that. So they could have been in the programme for, say, 80% of their actual qualification and then leave before their final achievements. So you know, that is difficult to evidence and justify how young people benefit from that aspect of the programme.
But presumably we have people that we've identified as falling under the category of being in need. How do we track them after they complete the modern apprenticeship to see what the destination, the final destination is?
Well, that's what I'm saying. The recent survey that we undertook showed a very high percentage had retained employment either with their employer or had been on to new employment. So
do you have a percentage for that?
I'll find that for you, yes.
Yeah. I mean, we've talked about achievement rates, which we've got here in your submission running at 79%. What needs to be done to improve these achievement rates? And what do you do with somebody that doesn't successfully complete or achieve the outcomes that should be associated with the modern apprenticeship?
I mean, the nature of our contracts with training providers, whether in the public or the private sector, is very much geared to output-based funding. So some of the qualification frameworks will achieve, in the case of electricians, is probably in a very high 90%. You will always, over a period of time, have, as I've said earlier, a young person that will decide to go and do something different. They might start in a retail job but decide to go and move elsewhere. That will show up in the system that they have not completed. We have a programme of contract management and contract improvement that our skill investment advisors will work with the training providers to actually, continually raise their performance, and you'll have seen that in the submission over a period of years that's got an ongoing positive improvement rate.
So you are in contact with these people after they've completed the...
They will still be within the labour market and will still fall within our services, but for those who achieve, the vast majority will be in employment and continue to work.
But what do you do with somebody that doesn't successfully complete the modern apprenticeship?
They would probably come back into the system through the kind of opportunities for all offers that are available, and if they present themselves obviously to our offices, they would be able to get further support.
But you don't have any formal process of tracking them?
We don't, in terms of coming off the back end of an apprenticeship programme. If they were under the age of 19, they would come back to the kind of benefits system, and that's where they get picked up by ourselves and local partners. Okay. We would probably follow up in terms of with the training provider in terms of understanding why they'd left the programme and what was the reason for that.
Do you think there'd be a benefit in having a more formal process of keeping contact, tracking these people in terms of the fact that they haven't successfully completed the modern apprenticeship? There's obviously a variety of reasons for failure. How far do you go in analysing that, and would there be a benefit in actually having a more proactive approach to deal with them?
The approach probably is pretty proactive in terms of the relationship with the training organisation. They will have built up a relationship and built up, a record of achievement with them. So I can go back and do a further analysis of those that we think fall out the system and we lose contact, but I would think the numbers are actually going to be pretty minimal, to be honest.
It might be interesting to see that figure.
Yes, I'm sure that Mr McGuinness...
Just to touch on one other thing which was mentioned previously, the Commission for Developing Scotland's Young Workforce, Ian Wood, I'll spare you the full quote, but he made a recommendation on the role that the modern apprenticeship programme has to play in supporting the Scottish economy, and it was in connection with aligning skills to support economic growth. What would your comment on that be? Are you supportive of that? Do you think it's the right way?
Yeah, very, very supportive. The submission would have contained the skills planning model diagram that we've used, and we'll continue to use. And that does three things. It tries to connect with employers to get their views. It helps shape the supply side provision in terms of colleges and our own provision. And it also informs careers guidance. So where are the actual jobs coming, what are the nature of them, and try and bring that to life. So the work that we've done through the industry leadership groups and with colleagues in the Funding Council is all about looking at that forward demand from industry and trying to shape provision and get a better return from existing investment and fill any gaps where we see opportunities in the future.
So what you're saying is the work you're already doing fits in with the report itself. So would you say there's any additional work you need to do, any additional realignment, assuming that the Wood report finds favour with yourself?
Our process in terms of this is ongoing. So there's a joint skills committee which sits between ourselves and the Funding Council, and we would do an industry review. So in terms of, for example, the energy sector or hospitality and tourism, and we would take our report to the Joint Skills Committee. They're an advisory body made up of both academics and business personnel, and it's them that take a view and offer guidance to both the Funding Council and to SDS in terms of where provision needs to be reshaped. So that process, as is described within the skills planning model, is ongoing, and I think we've made good progress since its adoption last year. So it's one to continuously improve in terms of the provision that we have.
Thank you. Liam.
Yes. Following up on that, obviously the headline figure on modern apprenticeships of 25,000 is impressive, and the work-based nature of it clearly has wide benefits as well. I wonder whether you have to hand figures on the numbers of modern apprenticeships that are in public sector, private sector and third and voluntary sector.
I don't have those to hand,
Right.
Mr MacArthur, but again, we can provide those.
I mean, that would be helpful. It's a question I've posed to the Minister in the past, and I've been encouraged to simply celebrate the fact that the 25,000 figure is met. I mean, I think going back to the quote from Sir Ian Wood's interim report, it's talking about more actively targeting modern apprenticeships towards supporting economic growth and areas of the labour market where the long-term prospects of young apprentices are greatest. Now, clearly nobody would simply look to rest on their laurels, but it does suggest that up until now there hasn't been that active targeting. From your own dealings, whether within the skills group or discussions with the Wood group, are you aware of any specific concerns, whether there's perhaps a lack of engagement from private sector in particular industries that needs to be addressed?
There's probably two things I would add. We've seen a fairly significant restructuring within the sector skill councils, which are UK-funded organisations. And I think a number of them have either consolidated or have lost Scottish managers in terms of their operation. So I think the kind of connection there to their industry base and sector skill councils are charged with delivering both labour market intelligence, but also maintaining and keeping qualifications up to speed with changes, whether it be in technology or others. So there's been a shift there. From SDS and the Funding Council's point of view, we're engaged with all the industry leadership groups, and a big part of the work we do around building skill investment plans is around a challenge process back into industry leadership group, and where possible getting somebody from industry to lead that. So in energy, for example, we've got Energy Skills Action Group, and it's Frank Mitchell from Scottish Power Networks that chairs that group. So looking at forward projections within the various subsectors of energy, and then looking at the provision that's available and seeing where we need to fill in any gaps, either in research or evidence base around future projections. So that's, I think, a very practical way of engaged with all industry leadership groups. So be somewhere in the region of 16 industry bodies that we've engaged with, inviting conversation and encouraging greater participation in terms of the skills and how we shape that future agenda.
In terms of the greater participation, I was going to move on to that. Is it your sense that you're drawing, or the modern apprenticeship scheme relies very, very heavily on a number of, say, usual suspects within particular sectors? Or has there been an improvement in that? I mean, my understanding is that the proportion of companies in Scotland engaged in modern apprenticeships is less than the proportion south of the border, which doesn't detract from the overall headline figure, but would suggest that the scheme is reliant upon a smaller number of players kind of punching above their weight.
You could say that. You're also not comparing like with like, so the actual commitment north of the border in terms of employing a young person in an ongoing job, I think is different from what you would see down south. We are looking at ways that we can potentially bring smaller employers into the programme that have not committed before, and there's a number of pilots been looked at in terms of shared apprenticeship schemes. Construction and engineering still play a big part in that offer. And within that, we're looking at a number of the engineering companies that are obviously involved in national groups, but haven't or have moved away over recent years in terms of committing to an apprenticeship programme, and that might have been because of certainty about the future. But we're actively engaged with the Federation of Small Business, Chambers of Commerce, SCDI, CBI, in terms of, I mentioned earlier on, our skills force and bringing together all the kind of national offers, trying to simplify the amount of information and access to services. So we're involved with all the business organisations trying to address these issues and hopefully minimise that young people are missing out on opportunities just through lack of information.
Okay, thank you. Jane Baxter.
Thank you. Morning. The committee has heard evidence excuse me, from a number of witnesses to say that the cutbacks in college funding are affecting the levels of staff and the capacity to do outreach work and to support people like female returners, people with additional support needs, perhaps those who want to reskill and change employment direction in later years. We've also heard that colleges can play an essential role in supporting all of that learning activity because they can be flexible, they can be located locally, they can offer childcare. But if the money's not there to do that anymore, then where does that leave all those people? And what can colleges do to improve their chances? And if there's nothing that colleges can do, what are the options for female returners, adult learners and people with additional support needs?
Right, the consequence of the reduction in college funding has fallen very largely on adults, and we seem to have retreated from the role of colleges in lifelong learning. They do what they can within the resources available, but as both Lawrence and I have said earlier, where 70% of provision is focused on young people, it doesn't leave much left for adults. And it's very curious in a way because it rather assumes that by investing in that initial stage of education and training, that jobs in the economy and society are going to remain static in the future, and we know that's not the case. We know that people's lives change, we know the economy changes, and yet we don't seem to have the capacity within the college system anymore to respond to that changes in terms of skills, and in people perhaps who've left the labour market as adults need to get back into the labour market. And very largely that can often be women, and we've seen in the numbers that we put forward that it has fallen disproportionately on women. Now, fortunately, up to a point, the government have put some extra money in and beginning to recognise. I would argue, however, that more needs to be done there, both in terms of the economy and what the needs are in the future, but also in terms of colleges' ability, in terms of community building, in terms of that social capital in Scotland, quite hard to measure, but when it's not there, you notice the consequences in the justice budget and the health budget and all the other things in terms of colleges that are so good at preventative spending.
I suppose there were two halves to your question, one of which was about cuts and the impact of that had on staffing numbers in colleges. John's very ably answered the other bit. Just to focus on the first bit of the equation, I think where we're in the middle of a set of reforms which are designed to produce larger, more efficient, more coherent colleges in regions responsible for provision in their regions and able to plan effectively. And I think that is a very important part of the reforms, in that is leading to a more efficient sector that is able to deliver provision in a very well planned and coherent way. That has led to numbers of staff leaving the system, but the evidence is that the system is more efficient than it was. I think that's an important thing. That's enabling it, therefore, to support some greater numbers of students than it would have been had we not made those reforms.
I'd offer a view. I mean, I think the last time I met Stuart, I was chair of Recare College for the last few years and worked with it through the merger process. So I make an observation that there has been a reduction in funding, but there's still a significant amount of resource available for the colleges to deploy, and they do that and do that very well. And I think that's, you know, they're a key resource across the country, and certainly SDS looks forward to working with them in a regional context and working with them to share information and try and highlight where the changes in the economy will be taking place.
Can I just ask another?
Sure, yes.
Just looking at funding, and I've noticed that this is a slightly different topic, but it's related. There's been a £1.25 million cut in the Energy Skills Academy, and I read in the notes that the work that's been done is now going to be mainstreamed, and I don't know what that means. What does that mean in terms of what's provided through colleges? Is that different sorts of courses or additional places, or is that 1.25 million just gone out of the system? What's being displaced to mainstream those places, and is that linked to the 1,500 low carbon fund places that I see reference to in other papers that I've got in front of me? I don't really understand what's happening around energy skills in the college sector and the Scottish economy?
That's, from my point of view, is probably a timing issue. So last year there was a significant investment made around capital investments through Energy Skills Scotland. A number of the universities and colleges in the North East benefited, Heriot Watt and Forth Valley College. So there's capital investment made. On the back of that, we also have the Energy Skills Challenge Fund. So last year, I think we supported about 750 through that programme. A number of colleges and trade organisations bid into that. So somebody like Orkney College, for example, had contracts. Low Carbon Skills Fund is something slightly different. We fund that on a 50-50 basis with companies. It might be for staff who are working into new technologies, air source heat pumps or whatever, and just require new skills. So it's a different funding pot. Government has made a commitment for 1,000 places this year through the Energy Skills Challenge Fund, and we're in dialogue with them just now around the final budget for that. But we've already taken, I think, probably about £750,000 to contract in terms of disbursement of that fund.
Just very quickly, Convener, and is that age related? Can people of any age?
Anyone can apply for that because of some of the operating conditions offshore. Then I think employers are looking for young employees to be kind of 21 plus. We're trying to target individuals who are also making transitions within their careers. So they might have been in automotive mechanics and maybe moving across. So they tend to be a slightly older age group.
Okay, thank you. Thanks, Convener.
Liam MacArthur.
Could I follow up a couple of points? Firstly, John, you were talking about the effect in terms of the focusing of support on the 16 to 24 age group, and you talked about a reduction in numbers in the 25 to 69 group. I think your figures in the submission you've made are from just over 160,000 in 2008-9 to figures for 2011-12, which are sort of between 108 and 109,000. I was struck also by the point you made in that submission about the fact that of those 108 or so thousand, almost two-thirds had no qualifications at all. I wonder what your feeling is about the effect that that reduction in numbers is having on the cohort that would have previously benefited from those learning opportunities in terms of their ability to get back into the work.
I think it's likely to have a very profound effect, because if they cannot get into college where they have no qualifications because the places aren't there anymore, then both in terms of their ability to get the skills down to the labour market are no longer there. But I would argue there's a more of a ripple effect, and it was struck by one of our awards winners a few years ago, and she was an unmarried mother. She went back to college, she gained qualifications, she had none. She said two things. One, her confidence rose to such a level she felt able to go back into the labour market. But the other interesting thing she said was her children now saw the value of education. And I would worry that if as a society we are denying older people that opportunity for education, there is that ripple effect that their children see it, well, why should I bother with education as well? So somehow as a society, if we don't respect education and inculcate that through parents to their children, there are real risks, I think, in that.
I think we're seeing the effects of that budget reduction I think you were talking about earlier in the evidence session. Are we seeing the impact of that now, or is it your expectation that we will see more of an impact over coming years?
I think it will be a long-term impact. I don't think it will be seen immediately. I think we'll see it in terms of the opportunities that are available for adults. We may even see it economically. It may be very difficult to prove, but it may be economically we will be less effective as an economy because we're not reskilling adults. And most of the workforce are not young people entering the labour market. They're people already in the labour market. And as the labour market changes, if we can't upskill these people, then I would suggest the Scottish economy is not going to be performing at its optimum level.
The other set of figures that leapt out to me from the submission was in relation to staffing numbers. You already conceded, and Mr Hills did likewise, the reduction in staffing levels. I think the figure from Q2 in 2009 through to 2013 is a reduction overall of about 3,200, and it's the figure I have here. It's been made rather forcefully to us, I think, last week or in an earlier evidence session on the budget, that while if you try to maintain the number of courses and the number of full-time equivalents going through with the reduced staffing, it may be more efficient, but actually the quality of what is being provided, maybe not in every instance, but in a number of cases, will be inferior because of that ratio of staff to learn. I mean, it was a point that was being made very forcefully indeed. Was this something that you would concede, Mr Henderson, is a concern? Is it something that's happening already?
What I would say is that the recent Audit Scotland report did say that we needed to be very careful in keeping a watch on the impact of losing quite a lot of experienced staff in colleges. I think it's too early to see any evidence what the impact of that is going to be. I think it's inevitable as funding has fallen, and given the large proportion of college funding that goes to staffing costs, that staffing levels would fall. I think we do need to watch through the regional outcome agreements, and I know that the Funding Council will be watching that, what impact that has on performance indicators. And I know that Education Scotland will be assessing externally the quality and the range of provision available in colleges. So I think the jury's out on the impact of that.
Sorry,
Sorry, I just wanted to also add to that. John mentioned the outcome agreements. One of the key things we put in place with the outcome agreements is measures about quality. One of the things we've particularly focused on is retention, which of course is a very important issue, and completion rates. And the colleges in their outcome agreements are committed to, whilst at the same time as taking forward these reforms, enhance and improve retention rates. And I would underline the point John also made about we're joint working with Education Scotland to make sure that maintenance of quality becomes an important thing, and that regional colleges use their economies of scale and their systems to effectively underpin ways of tracking and supporting learners and providing the support that's required through the process.
I mean, obviously the headline figures and quality assurance will be helpful, but perhaps what it doesn't capture is those who perhaps need additional levels of support, which becomes more difficult when your ratios are larger than they were previously. Is there a way through the outcome agreements that's being picked up and dealt with?
Indeed, we would require all the colleges to develop individual learning plans with individuals reflecting their needs, and part of the funding package that's provided includes an allowance for extended learning support and these other aspects. And the particular focus that we have with Education Scotland in their reviews of colleges is the extent to which they're supporting people with those needs. I think it's worth also saying that if that support isn't provided, then you won't see the results in terms of retention rates and performance indicators. And it is quite important to reflect that individual colleges have set themselves targets to achieve for that, and they will be held to account for delivery of those targets.
Can I ask a brief question to Mr Henderson? You quite rightly pointed out that we have to be careful about the balance we strike between young learners and adult returners in terms of the balance of the economy. And I certainly agree with that. But wouldn't you agree also that in a time of economic difficulty that we currently face, it's quite right that we reprioritise resources from those that are currently, or certainly have been in the recent past, going to college courses who are over retiral age, and that resources shift to those at the younger end of the scale, the 16 to 24-year-olds, rather than the post-retirement age learners?
Oh, I think if you accept the proposition that college budgets should be cut, then I would accept that given the high youth unemployment, it is right to prioritise what resources are available on the young. What I would suggest, though, is that just as we take the view that investing in the capital infrastructure of Scotland is very important, the bridges, the roads, the new railways, I would argue investing in capital, human capital in Scotland is equally important. So I think the problem is the budget is too small and the impact has been disproportionately large on adults. I think we should keep the focus on young people, but I'd like to see more resources made available to have more provision available for adults.
Okay, thank you. George Adam.
Yes, I'd like to ask probably Gordon questions on partnership working. It's basically just to ask what do you see, what steps have been taken by SDS to ensure that everybody's joined up, from schools to colleges to employers, small and large. You know, you've answered some of it today, but you know, what steps are you doing to actually ensure that that's all happening? Because that's no easy task for you.
Correct. I think from our early days of operation, we made the offer and it was accepted to have a service delivery agreement with every single local authority in Scotland, and I don't know if there's many national agencies that had went down that route. So the offer was there, both from our services within schools, but obviously to those for training and support, for that to be reflected in an agreement with each local authority, and then that's been embodied into the community planning partnership. And that's like a lot of other agencies now, where we would see that level of activity taking place. It would be through local employability partnerships that would be operating as part of the community planning partnership. I talked earlier on about our work with the industry leadership groups, and we're following that up this year in conjunction with the Funding Council and Scottish Enterprise around doing regional skill assessments. So we've been piloting one in the Highlands, we're nearly completing that, and we're going to undertake that across the board. So I think there's a view after the demise of local enterprise companies, there was not that level of I suppose scrutiny or understanding about what was happening with local and regional labour markets. So that's a new service offer, I suppose, that we're bringing to the table to help inform future planning. So as their training provision aligned to the future needs of the labour market, and I think it's just that kind of commitment and ongoing process. Also touched earlier on our skills force in terms of the partnership offer database. It was a challenge back from Mr Swinney in terms of better aligning Scotland's employability service. So probably for the first time ever, everything's on the one website. It's still not perfect. We're still working with partners to tweak and shape that, as well as communicating heavily with businesses to make sure that they're aware of what's happening. We've got a modest resource on the ground to work with local partners in terms of connecting companies up to that service. So I think, you know, we've put a great deal of store in it. Our chief exec leaves us open to challenge at all time from partners if they feel we should be getting more. Then we sit down and talk that through. But I think relationships with partners has been pretty positive.
Okay, thank you. Lawrence, did you want to contribute there?
Only just to strongly support the joint working that's happened between my organisation and SDS, particularly about bringing together the best strength that we can of demand in a sector and in regions.
Okay, thank you. Liz.
Obviously, as a committee, we're asked to scrutinise the budget in the normal way, and this committee and its predecessor have had issues in recent times about the interpretation of certain budget lines. Now, could I just ask about this reclassification of colleges? And this is not about the debate whether it's the right thing to do or how it's being addressed. But as I understand it, the reclassification now means that the central government, the actual total, the full expenditure and income for the sector now has to be set against departmental lines. Is that correct?
Effectively, yes.
Right. Could you tell us as to how, or what the impact is on helping us to scrutinise the income for the college sector and how that money is spent?
I suppose there are now in the budget a set of lines that are about the income that the colleges earn themselves, and that essentially is the commercial activity. I think the focus of the committee ought to be on the line which is the direct government support, which is buying education provision, as we always have done, for students in Scotland. I think that's the line you should focus on. The other lines are really to do with accounting conventions in government accounting.
Could I ask then, when it comes to the reclassification, the reserves, as I understand it, unless moves are made to put them in arm's length trusts, that becomes one body of money rather than being within separate colleges.
I think the technical issue is if that money was spent, it would be spent against government treasury targets for spending, and therefore it would have to be given budgetary cover by the government, which effectively means that those reserves would be frozen. They couldn't be effectively spent. So the arm's length trust idea is one that creates an ability for colleges, or that money to be used by colleges for the benefit of education in their regions going forward.
So can I just be clear about this? I'm a bit confused on what exactly it means. If these separate trusts are set up, does that college still have the ability to decide how that money is spent, or is it up to the Scottish Government to decide?
It's up to the trust to agree how that's spent, and the way we would imagine it would work would be the college or the region would provide a request for that money to that trust. When the money was put into that trust, it would be specified for the purposes that would be spent, which would only be for that local the development of college education in that locality. So it would not be decided by the Scottish Government.
So in terms of our scrutiny about how effective college spending is, we would still have to have a look at a budget line that's obviously defined in a different way now.
Indeed.
Plus also scrutinise these trusts. Is that correct?
I think it is important. The way those trusts will be set up will be so that they can only be used in line with government and policies. It is important that those trusts deliver that requirement, but they will be legally set up to do that.
So will these have charitable status accorded to them?
They will. That's the plan at the moment, yes.
Is that your understanding, Mr. Yes. Okay, thank you.
Oh, okay, thank you very much. Can I thank the witnesses for their evidence this morning? It's again been of great assistance to the committee in examining the budget, the draft budget I should say. Our final evidence taking session on the draft budget will be next Tuesday, when we'll hear from the Cabinet Secretary for Education and Lifelong Learning. Given that we have agreed to take our next two items in private, I therefore close the meeting to the public.